Jackie, I'm seeing attorneys from all different cases.
Let me do one thing and then I'll ask the courtroom deputy to open court. Are you ready to proceed, Judge Wilkinson?
All right, Mr. Gibbons, we start our first case, Connor versus Cleveland County, and when you're ready, we'd be pleased to hear from you.
Thank you, Your Honor. May it please the court, my name is Phil Gibbons, and I represent the appellant, Sarah Connor. Connor alleges violations of the overtime provisions of the Fair Labor Standards Act and breach of contract against her former employer, Cleveland County, North Carolina. The district court dismissed Connor's FLSA claim under Rule 12C and declined to exercise supplemental jurisdiction over a breach of contract claim. The appeal focuses on Connor's FLSA claim, and the primary issue before the court is whether the FLSA requires an employer to pay all regular straight-time wages owed to an employee before it can treat additional compensation paid to the employee as overtime pay.
What's the advantage to you from having it done that way?
Your Honor, I missed that question.
What is the advantage of you from having the computation proceed in that fashion?
Under the FLSA, Your Honor?
Computing the straight time before moving into overtime.
Well, Your Honor, under their pay plan, they compute the both the straight time and the overtime under a pay plan that results in a reduction in their salary. And so there is no advantage under their pay plan. It works to the detriment of the employee because the employees don't receive their full salary.
Mr. Gibbons, let me ask you this. Is the county appropriation ordinance in the record before us, or is the 14-day pay plan in the record before us?
Your Honor, the county ordinance is not in the record. It was alleged in the complaint. The pay plan is in the record. It was in the record for a limited reason, to demonstrate that the defendant, Cleveland County, was aware of the term 24 hours on, 48 hours off. Before the district court, they represented that they did not know the meaning of that term. And so the Section 14 pay plan was entered into the record, and it repeatedly refers to their employees as 24-hour on, 48-hour off personnel, including it states that this is the method we use to pay overtime to 24-hour on, 48-hour personnel.
Is there a written employment contract in this case?
In this case, there's an ordinance that specifies that all county employees are to be paid a salary, and that ordinance applies to Connor, and it also applies to the class that she seeks to represent. And under North Carolina law, there's that relationship, the promise to pay the wages is a quasi-contract, and it's been recognized under state law as a contract.
Where do we find the hourly wage?
Your Honor, it would be the calculation. It would be under the Fair Labor Standards Act. Employees are entitled to be paid time and a half for all hours worked over 40.
No, I understand that, but where do we find the hourly wage for straight time?
For the county, what they do is they take the annual salary, they divide it by the total number of hours that the 24-hour on, 48-hour employees work, which is 2,928, and they come up with an hourly rate. They multiply that hourly rate by 1.5 times, and that's the overtime rate paid for each hour worked over 40.
And there's a dispute over the hourly rate?
The dispute comes in where they repay the regular wages, because the regular rate of pay is the amount. It's an actual mathematical amount. It's not a label. And the regular rate is supposed to be the amount that you actually pay your employee. And it's also how you get to the overtime. It's 1.5 times.
Right, well, what is the regular rate that you're paying? What is the hourly rate that you're paying this employee? Do you know? That the employer is paying the employee?
It varied at different times, because she made different amounts, and each member of the class made different amounts. But at one point in time, she made $36,900, and they divided that by 2,928 hours, and that came up with an hourly rate of pay. And then they multiplied that hourly rate by 1.5 times.
And what was the hourly rate that they came up with?
I don't have that in front of me. She worked for them for several years, and it changed over time. But the hourly rate that she was paid, that's not the problem in this case. Where the problem arises is that they used a portion of her salary to subsidize the overtime payment that they owed her. So in other words,
so let me ask you, so we can maybe this can get a little convoluted in terms of where we're going. The issue here, it seems to me, whether or not first, do we in fact in Monaghan recognize this overtime gap, overtime gap time as a claim? And if we are there, then could you give us pick a period of time in which you say this thing is violative, so it illustrates what the problem is, and use some numbers to let us know how it is that your client has been underpaid under this scheme in light of Monaghan. We'll start with the assumption Monaghan does do that. There will be some contention on that. But if Monaghan does recognize such a claim, then how is it that your client is underpaid, or has been underpaid? Using a specific example, because that helps to simplify it. I mean, we're going to bounce all over the place if we're looking at different time periods here, but the concept is the same for one that fits for all, I think.
Okay, I think it may be easier to use a hypothetical, because it does get very convoluted unless you're working the math.
Well, use the hypothetical and
okay.
To the extent it is applicable in illustrating what you are talking about here, where you don't have a definitive type of a hourly wage, but under these circumstances, you maintain that the Monaghan recognition of overtime gap claim is being violated here.
Yes, Your Honor. So let's assume that I have an employee and I agree to pay her a salary of $500 for her regular straight time wages, and I agree to pay time and a half for all hours worked over 40. At the end of the week, the employee works 50 hours. We would calculate the regular rate of pay by dividing $500 by 50 hours, and we'd come up with an hourly rate of $10 an hour. That would be her regular rate. The $10 would be multiplied by 1.5 for $15 an hour. So under these facts, I'd owe the employee $650 for that week, 500, which is her salary, and 150, which is the overtime wages. That'd be 10 overtime hours times $15 an hour. But let's assume on payday, instead of paying her $650, I provide a paycheck for $550. Instead of paying the $550 that I agreed to, I take her regular rate, which is the $10, and multiply it only by 40 hours to come up with $400. And then I pay an additional $150, which I allocate towards overtime. So on her pay stub, I'm showing that $400 is her straight time pay, and $150 is her overtime pay.
I wonder if you're not making this more complicated than it needs to be. And I have the same question that my colleague Judge Wynn has about exactly how we go about these computations and exactly how you're being underpaid. And I wonder why the computation isn't as simple as you have the number of hours worked per week times the amount per hour, and you compute that initially. When you get to that, you pay the straight time pay first, which is the number of hours that would be 40 or less, and then you would find out how many overtime hours there were, but I don't understand why it isn't just a computation which just takes the number of hours worked times the amount per hour, and you do it on a weekly basis. And then you take all the straight time, which is 40 and under, you pay that at the regular rate, and then you pay any overage at the 1.5, the overtime rate. And so, you know, maybe I'm too simplistic, but I thought that was the way one would normally go about it, and I don't understand it. It seems to have assumed a very convoluted quality.
The reason it's convoluted is because of the Section 14 pay plan. What you have to realize is these employees are promised a 1/24th of the salary as the regular pay. They do an additional step where they reduce the regular salary and pay an amount less than their salary. So in other words, if the salary is supposed to be 500 and you have 150 in overtime, they're paying 400 to you plus the 150 in overtime. And the question is whether they can underpay the regular wages and simply allocate money to overtime and say, well, we satisfied our overtime obligation. You can see it here on the pay stub, without first paying all of the underlying regular wages. And that's what the statute in Monahan addressed, is whether during weeks you worked overtime, an employer has to first pay all of the regular straight time wages before that employer can count the money he allocates towards overtime as overtime.
Does this occur where you have, in your example, you indicate the company had agreed to pay the salary, the $500, which made the difference of the $650 in that. And then in the example, you went to the $10 per hour. If it was straight hourly wage, no mention of a salary, you make $10 an hour, then if that was the just that and that alone, would there be any violation to pay them $550 with a straight $10 an hour wage with no mention of a salary?
Well, again, and this is what the holding was in Monahan. You have to go back and look at the agreement of the parties. If the agreement was to pay $10 per hour, then it would be an hourly employee, and that would be correct. But if the agreement was to pay $500 per week, and then you went and did a mathematical calculation that reduced that, then it is incorrect because you haven't paid all of the promised wages.
So the difference, I'm just making a difference because I think that's where we are sort of not following you quite well, and that is if it is nothing but just an hourly rate we're talking about, that's one thing. But in this instance, you actually have a promised salary. And then converting that salary using that formula actually reduces it to an hourly rate that yields a lower rate than what is promised when you add in the actual overtime that's paid here.
Yes, Your Honor.
Mr. Gibbons, why isn't it reasonable to assume that if the ordinance provided that an employee like your client is to receive $36,900. That's her salary, and that covers her working 40 hours a week. Where do we get this idea that overtime is included in that $36,900?
Well, it's not supposed to be included, Your Honor, but the mathematical calculation that the county uses includes it. What they do is after they use the $36,009 as the regular rate to figure out the overtime, but then they do an additional math step that takes about a third of that salary and pushes it into overtime. And they simply label that money instead of regular wages, which is what the promise is. They call it overtime wages. The problem with this is if you look at Section 207, which is the statute under the Fair Labor Standards Act that addresses overtime, overtime is based on the regular rate of pay. Right? Back in 1945, the Supreme Court said that the regular rate is not a label, it's a mathematical fact. And so you should be able to go back and reverse engineer how the overtime relates to the regular rate. And If they use 36,900 and turn that into an hourly amount for purposes of overtime, when you reverse engineer that, you should end up back at 36,900 for your regular wages. Otherwise, there's a regular rate violation. They're running afoul. It simply becomes a label instead of a mathematical certainty. And so under these circumstances, this is a math issue, but it's a math issue that results in the county using part of these employees' salaries to pay their overtime.
But how do we know that this is impermissible to push 1/3 into overtime until we actually know the number of hours worked?
Well, see, Your Honor, this is the issue that's really before the court here, because this was decided under a Rule 12C motion. There is no record before the court to determine exactly what the arrangement is or the agreement is between the parties. The plaintiff
in other words,
states
it could be legitimate to push the 1/3. It could be legitimate depending on how many hours you actually work. It either could be that determines the legitimacy of pushing part of the regular time into overtime. If you worked under 40 hours per week, there wouldn't be a problem, would there?
if you worked less than 40, no, but in this situation, these employees work 48 hours a week, then they work 72 hours a week. They work on a rotating schedule where every week they work overtime. The problem, again, comes back to what is the agreement between the parties? If the agreement is to pay the full amount of the salary as your regular wages, under the Fair Labor Standards Act, you have to first pay all of those wages before you can count additional compensation as overtime. And what they're doing here is they're figuring out the overtime rate, paying that for all of the overtime hours, but going back in and recalculating the salary through a mathematical problem that ends up apportioning about 2/3 of their salary as regular wages. And then the other third ends up not being paid as regular wages. And their argument is, well, the agreement was to use that to pay overtime. It's mathematically impossible under the Fair Labor Standards Act, though, when you look at the regular rate calculation. If you start with $36,009 as your regular rate, that is the amount that you're supposed to pay to the employee exclusive of overtime. And if you use that as the regular rate calculation, which they do, and you come up with an hourly rate for overtime, and then when you pay the regular wages, you fail to pay the full amount, you're in violation of the Fair Labor Standards Act.
All right, so what,
you're in violation of Monahan.
Is the bottom line of what you're concluding is that they've got to pay the full $36,900 regular time before they even get into overtime?
Correct, on a per pay period basis. I mean, in other words, 36,900 divided by the 24.
And you're saying that the employee is due that regardless of the number of hours worked because it's a contractual obligation?
Correct. That's their salary for their regular straight time hours.
All right,
overtime is paid in addition to that.
Regardless, their salary of $36,900 is their salary, and it doesn't make any difference how many hours they work. Contractually, they are entitled to the $36,900.
Correct.
And then how do you figure? And they have to pay that initially, and then how do you go into the overtime? In order to get the overtime, you do have to go into the hours worked, don't you?
Well, yes, yes, of course you have to go into the hours worked, and they do that, right? That's the issue here is they actually label money, they pay money that they allocate as overtime, but they underpay their regular wages. And that's exactly what the issue was in Monahan and what the regulation that's at issue here says that you cannot do. You have to first pay all the underlying regular wages before you can treat additional money as overtime.
The $36,900, that's exclusive of the number of hours worked. It's not dependent on that at all.
Correct. Correct.
All right.
They, yes.
Oh, okay, once you get that, they say, all right, that's the salary. That's the regular time. You have to pay that regardless of how many hours you work. And then you go into a separate calculation, which is the overtime. But to figure that, you do have to look at the number of hours actually worked beyond 40, because that would be classic overtime. In other words, your position is you have to pay the 36.9 exclusive of hours worked. You then go into overtime and find out, based on, you have to then make the calculation of the number of hours worked to get to the overtime. And that is 1.5, whatever the hourly wage might be. But doesn't that all depend on how the employment agreement is structured?
Yes, Your Honor, and that's the issue before the court. At 12C, it was improper for the court to simply find that the agreement was just a matter of contract and it had no bearing on the Fair Labor Standards Act. In Monahan, what the court found is in weeks that you work overtime and there's an allegation that the regular wages have not been paid, the court has to first look to the agreement of the parties to determine whether all the regular wages had been paid.
All right, so you're saying that they cannot contract just for $36,900 as an annual salary and sort of leave the Fair Labor Standards Act behind?
Well, Your Honor, these employees are non-exempt employees. And
right.
in the ordinance, the way that the county has agreed, rather than using comp time, what they agreed to do for these employees is pay them time and a half based on that hourly rate, based on the calculation that we discussed, the salary divided by the 2,928 hours. But the overriding issue is the fact that they don't pay the full salary. Right? They pay less than the full salary plus an amount of overtime that our position is they arbitrarily label as overtime, because if the Fair Labor Standard Act is correct and Monahan's correct, that money can't be treated as overtime until they've paid that salary.
All right, let me ask my colleagues, Judge Wynn and Judge Floyd, if they have any questions of you. Otherwise, we're going to go directly and hear from Mr. Edwards. Judge Wynn, do you have any questions?
I have no further questions at this point.
Judge Floyd?
No, I don't have anything further.
Thank you, Your Honor.
All right, let's hear from Mr. Edwards. Mr. Edwards, we are happy to hear from you.
Thank you, Judge Wilkinson, and may it please the court. We are here today to ask that this court affirm the district court's judgment. I think your colloquy with Mr. Gibbons has highlighted two significant flaws in this complaint that support the decision made by the district court. I hope in my second point to be able to add some clarity to this contract wage calculation issue. I understand it is a very complicated issue, but I want to first start by addressing your concern, Judge Wilkinson, that we don't actually know if Ms. Connor has worked so-called overtime gap time. So assuming, without conceding, that her salary was $36,900, there are no allegations in the complaint under the standards set out by this court in Hall against DirecTV to show that she actually worked more than 40 hours in a given work week. Instead, what we see in paragraph 9 of her amended complaint is that she was just scheduled to work. And so the first thing we need to know to determine under this court's decision in Monahan that overtime gap time was worked is the total number of hours worked in a particular week, because regardless of what the overtime gap time discussion in Monahan means, the court emphatically rejected straight time gap time, or gap time underpaid salary in weeks in which no overtime was worked.
But
So,
in order to find out the number of hours that she actually worked, don't we need some discovery and some further look into that on the part of the district court? Because the difficulty is that she was scheduled, as I understand it, to work 48 hours a week. And is that prima facie evidence that she worked more than 40 hours a week, given the fact that she was scheduled to work 48?
no, Judge Wilkinson, I don't think so, and here's why. So in the Hall decision, this court said that under the Fair Labor Standards Act, regardless of, even though it did not adopt this full accounting standard that some district courts have used, the court said, we're not adopting a form pleading where the plaintiff can say, I worked 40 hours or more in all or some work weeks. You can't just plead that you worked overtime. And here, Ms. Connor's allegation is one step removed from that. She's actually alleged, I was scheduled to work overtime. And so I don't think at this stage, I am sympathetic to the idea that on some of these issues, discovery might be proper, but not here, where Ms. Connor knows how many hours she worked in a given work week and could have alleged that. I would submit to the court that it is strategic to allege I was scheduled to work rather than I worked.
Well, who has the burden of record keeping here with respect to the number of hours she worked? Is that the plaintiffs or is that the counties?
In Hall, the court did recognize that the employer has kind of all of the information that the plaintiff needs. But even so, the court said it's not enough to simply allege, just as a matter of fact, I was scheduled to work overtime or I worked overtime in some weeks. There does need to be some recognition that there was overtime work in a specific work week. And here, Ms. Connor has not done that.
So let me understand where you are. It seems as though we at least are moving under the belief that Monahan does recognize an overtime gap claim. You don't seem to gap time claim. So we haven't broached that issue. You moved into the evidentiary aspect of it, and that is dealing with the complaint alleges. And if I understand you correctly, you are saying that this complaint is insufficiently alleging that she worked more than 40 hours in a week, and that she does not allege appropriately that she's not been paid all of the straight time compensation for which she was owed. And that would seem to, if she had done that, that surely would seem to implicate Monahan insofar as an unpaid overtime gap time claim. But your allegation or your statement is that the complaint insufficiently does not allege, even when we use all of the pleading liberalities and everything, it insufficiently alleges that she worked more than 40 hours. Is that where you're hanging your head on this particular case? Because that seems to be where you're going, to me.
Judge Wynn, I want to take that in a couple steps. So all of my arguments up until the very last argument I intend to make do assume that Monahan recognizes this claim, because the county's position is that for at least two reasons, the complaint is insufficient to state a Fair Labor Standards Act claim. So
I want to make sure in terms of the facts of what's here, as I recall, it seems like her schedule says 24 hours on, 48 hours off. And that seems to indicate if you do that, that's more than 40 hours. If you're 24 hours on, 48 hours off.
I agree that is more than 40 hours in a given week. I do think, though, that the issue is that Hall.
No, let's stick with where we are in there. I want to make sure we get that. Then we'll tell the application of all. But so what you've just said is the complaint does sufficiently allege that she works more than 40 hours per week. Is that right? Okay,
No,
but so let me make sure I understand it. Schedule's 24 hours on, 48 hours off, then 24 hours. That's 48 hours. So why is that not more than 40 if you allege that?
She's alleged she was scheduled to work. She has very carefully not alleged that she actually worked any time in a given week.
I thought she said her schedule is that. I am scheduled to work, but that's you sort of work by on I guess in terms of the type of work that they do, you're dealing with police officers, you're dealing with first responders, all. If you have a schedule, that's what you work. I don't know how else you say it. You say, well, I work this, I work that, but if the schedule tells you this is what you do you have anything to indicate this is not what she's supposed to be? In other words, I am designated to do this. It's a terminology. I don't know if how do we get hung up on schedule if that's what she does?
So I think there are a couple responses to that, Judge Wynn.
Because that's kind of the way they talk, isn't it? If police officer has a schedule. I have a schedule to work 24 hours on, or a nurse has 24 hours on. Isn't that kind of it? So, but you're turning this on to say that doesn't mean she actually did it, or it's not sufficient to say she does it just because her schedule says it, which means she can violate a schedule to a lesser amount. She doesn't have to work 24. She'll work 20 hours, says, okay, I'm only going to do 40, and I'm going to just do my 20 hours, I'm out of here. Is that where you were going with this?
I think more facts are needed to demonstrate. So if we look at, for example,
that's what Judge Wilkinson said. That's what he said, why discovery is needed.
I don't think it's discovery. I think that Ms. Connor, invoking the jurisdiction of the federal court, is required to plead sufficient facts to show that she actually worked more than 40 hours in a work week. If we want to talk about schedules, and we look at your opinion in Fire and Safety, the 2019 decision that Ms. Connor cites, the employees in that case were scheduled to work a full hitch, but in many occasions they worked less than a full hitch. And so there was a dispute about the blended rate that they were paid. But I think that that's emblematic of the fact that sometimes when a person is scheduled to work, 48, 72, 168 hours in a work week, or in a period, it doesn't necessarily mean that person actually worked that amount. And so I don't think—
Mr. Edwards, let me ask you this. At JA 21, there is a consent to become a party plaintiff. And this client, Ms. Connor, says, by signing below, I state that I have been employed by Cleveland County Emergency Medical Services within the past 3 years as a full-time emergency medical technician, and that I work 24 hours on and 48 hours off schedule during 1 or more weeks. What? That's in the record.
It is, Judge Floyd, and I believe we dealt with that in our brief. As I read that is again just a statement she was scheduled to work. I worked the schedule. It means she, in my understanding, that she was scheduled to work that time without actually—
It doesn't say I was scheduled to work. She says that I worked 24 hours.
Judge Floyd, even if that's true, the court can still affirm the district court's judgment by determining that under the framework set out in Monahan, she's not been underpaid her contractual wages. And so the Section 14 pay plan, which is at Supplemental Appendix 1, is very complicated. But I want to walk the court through what Ms. Connor's salary was versus what the target compensation identified in the ordinance it was. Ms. Connor says that she was paid a salary of $36,900, and that's not true. If we look, there are several pieces of her employment contract. And so in Monahan, this court looked at a host of official policies to determine what the employment contract was. And so we do have the ordinance that requires semi-monthly pay. We also have where that $36,900 number, which appears at paragraph 46 of the complaint, that number comes from a document called the Cleveland County Salary Ranges by Grade and Classification.
Mr. Edwards, let me ask you this, because what Judge Wynn and Judge Floyd has said resonates with me, and that is, when you say that she's scheduled to work 48 hours a week, and then there's a dispute about whether she worked the amount that she was scheduled to work. But if she's scheduled to work 48 hours a week, isn't that prima facie evidence, at least, maybe not conclusive, but isn't that prima facie evidence that she did, in fact, work 48 hours a week? And wouldn't that be something that would be best sorted out by the district court on remand? Isn't the fact that she was scheduled for that many hours enough to get her over the 12B6 or 12C hump? And how she would fare on summary judgment or beyond, I don't know. But when you've got that, what seems to me prima facie evidence that your own schedule indicates she was supposed to work 48 hours, it seems to me that may be a kind of a shift in the burden of production. So why isn't it appropriate? And this is so convoluted and everything, but I want to make sure that we're not confronting here a very tricky system, which is depriving by a mathematical sleight of hand the money that this employee is due under the FLSA. And what I'm concerned about is, why don't we send this back and say, you know, the county should explain why she didn't, and she should explain that there should be discovery as to whether or not she worked the hours she was scheduled to, and then go from there and say, once that question is answered, then the question becomes whether the county has, under the Monahan case, which, you know, is not my favorite, but it's our precedent, and we've got to follow it, because there it is. And we need to find out under Monahan whether one way or another there was a pushing of overtime into regular hours of work in order to avoid overtime pay or some other kind of payment. But why doesn't this case just need a whole lot of fleshing out, more than it was given? That's the question I have.
Judge Wilkinson, I hear kind of two questions or two concerns. And so on the first concern about the amount of hours she was scheduled to work, I think that the court can affirm the district court's judgment regardless of the number of hours she was scheduled to work, because Ms. Connor has included sufficient allegations in the complaint. She's referenced the Section 14 pay plan. She submitted it to the district court. And if we look at all of the aspects of her contract, she cannot show that she was underpaid as Monahan uses that term. So she can't show that the county shorted her any money under her contract. Ms. Connor admits that the Section 14 pay plan is part of her contract because she admits that the county's EMS's standard operating guidelines are part of that contract at paragraphs 42, 43, and 44 of the complaint. So she says and recognizes that the county is bound by those, and then she herself doesn't want to be bound by them. If we put that $36,900 number through the Section 14 pay plan, it gets a regular hourly rate of $12.60 an hour, and that's what she was paid. And if we look at the regular rate based under the interpretations, 778.108 and then 778.113, which tell us how to calculate the regular rate for semi-monthly pay schedules, her regular rate receiving $1,092 every semi-monthly pay period was $12.60 an hour. Ms. Connor's fundamental allegation is a misunderstanding of the county's pay plan. The county's pay plan is not, it's not a shell game. It's not, in many cases, where there's a blended rate and there's a real dispute over what the regular rate at which overtime is due is. The county's contract itself is part of the pay plan is part of that contract in addition to the ordinances. So Ms. Connor is skipping a step and instead saying, I'm entitled to $36,900.
Well, doesn't that all follow if this was a state contract action? I think everything you say seems to me to follow. That's not what the trial judge did here. The court didn't base this on any actual merits of the claim, but instead on the fact that the employment agreement facially did not violate minimum wage or overtime provisions under FLSA. So, I mean, it's an apple and oranges thing. That's what you're trying to do, is to say this doesn't belong in federal court, pursue the state claim. And if you pursue the state claim on it, a contract thing, it seems to me you probably are making a really good argument. But that doesn't seem to be the direction that this goes in terms of the Fair Labor Standards Act.
Judge Wynn, I think I understand your point that that's not what the district court did, but as we've indicated in our brief, this court's reviewing the district court's judgment, not the particulars of its decision. And so this is the same type of
so we can ignore its reasoning and create our own here, because we can, in other words, we can become the district court here and do what you say should be done as opposed to what was actually done.
Judge Wynn, I believe that this court can determine that the FLSA claim is infirm in the first instance on this basis. The district court, I hesitate to say this, but I will not defend the district court's application on the merits here. But even so, the result is right. And in this case, judicial economy counsels in favor, where Ms. Connor has pleaded herself out of court by demonstrating what the terms of her contract are, and then demonstrating that the county satisfied those contract terms under Monahan. The first step of the Monahan test requires.
Well, facially, she's pled, and you disagree that if she's facially pled that she worked in excess of 40 hours and was not paid overtime for it, then she makes the allegation. You say that Hall. I gather what you're saying is that Hall requires some type of actual proof. I don't quite read Hall as being so rigid. It seems like you only need a plausible basis for it in the complaint, and that seems to be satisfied here.
Judge Wynn, I want to separate these two arguments. The Hall standard only relates to the number of hours that she's worked. In this case, if you assume she worked every hour for which she was scheduled, she has still been paid every dollar owed under her contract. And we know that because she's alleged her quote unquote salary, which I think is a legal conclusion as to what she's entitled to be paid. And this court can look at the other documents referenced in and integral to the complaint.
Well, why should we be looking at the other documents? Why can't the district court look at all the other documents and find out whether she's been paid, she's been paid the straight time that she's owed, whether the straight time was calculated initially, and then whether there was overtime, and whether she was paid overtime after the straight time was calculated. But I don't understand why that is our job to do all these calculations up here without an initial period of discovery for the district court to say what you now say, that she's been fully paid. But I'm not sure the district court reached that conclusion. And I mean, if in a reasoned fashion, and I don't think it's our job to go through all of these calculations in the initial instance. Maybe later on. But at any rate, I'm going to ask my colleagues if they have further questions of you. Judge Wynn, do you have more questions of Ms. Edwards?
I have no further questions. Thank you.
All right, Judge Floyd?
No questions.
All right, Mr. Gibbons, all right, you have some rebuttal time scheduled.
Really want to take it.
Your Honor, I go back to my original argument that under Monahan, the court needs to first look at what the employment agreement is. The Section 14 pay plan, whether it's part of the contract or not, if it violates the FLSA, in other words, if by moving the part of the salary into overtime is not permitted under the FLSA, then you've got an unlawful contract. It's not enforceable. And we would fall back to what the salary should be. But again, as you pointed out, Judge Wilkinson, it's not your job to do that. This is the job of the district court, and my client should have the ability to prove her case. And we would ask that the case be remanded.
But Mr. Gibbons, as I understand it, the bottom line that you're concerned about here is that the company may have been moving overtime pay into regular salary. Is that correct?
Well, my main concern is that if indeed she was entitled to $36,900 in straight regular wages, she wasn't paid it. And the employer concedes that, they agree. And what they're saying is that under their version of the contract, they don't have to pay that. They could split it up and apply some of it to overtime. And what I'm saying is if you use the salary to create or to calculate the regular rate, that's the amount under Supreme Court precedent that you're supposed to pay the employee exclusive of overtime. And Cleveland County admits they don't pay that. They use $36,900 to determine the regular rate and create the overtime amount, but then they turn around and pay 2/3 of that amount as regular wages. And again, under Walling, going back to 1945, you can't just label something as the regular rate. It's a mathematical certainty and an actual fact.
In very simple terms, without going through this, and this, just tell us in very short, brief, commonsensical terms what it is, in a few lines, that you are concerned about. Brevity is important here.
What I'm concerned about is that the company allocated money as overtime pay. They paid my client money that they designated as overtime without first paying all of her regular wages, which violates the regulation and violates the statute. And on that issue, this idea that she pledged she didn't work overtime, her entire claim is that the money you paid me and allocate it towards overtime for the overtime hours I worked can't be treated as overtime because you didn't first pay my regular wages. But doesn't it seem to follow that if the county paid her overtime?
It is a bit odd. It is a bit odd, Mr. Gibbons, because normally, or a lot of the FLSA plaintiffs come up here and they want time classified as overtime because they get time and a half. But it seems to me you have something of a reverse spin in a way, which is if you want overtime classified as regular time. And I understand why you do, but isn't this a little bit of a reverse spin in the sense that most plaintiffs want time classified as overtime, and you're saying no?
Well,
I
way,
think I understand why, but it's an odd spin, isn't it?
It is, but it's the employer's doing, right? If they're going to allocate money and label it as overtime and not pay the regular wages, the result's the same. The employee still ends up getting paid less, right? If they pay the regular wages but then short the overtime, the result comes out the same. The employee makes less than he or she should make, and that's the result here. But what's interesting, and we plead this in the complaint, as of January 1st, 2018, after we filed the lawsuit, exactly the Cleveland County did exactly what I'm saying they should do here, and they started paying the entire salary, and they took the step out that reduces the salary as part of the Section 14 pay plan. And that's what the court's going to see if this case gets sent back, is that they did correct this and they started paying the actual full salary as they should under the Fair Labor Standards Act from January 1st, 2018 on. Your Honor, I'm out of time.
All right, thank you. Do my colleagues have any questions?
No, Your Honor.
Judge Floyd?
No, sir. No, sir.
All right. Thank you both very much for your presentations. We appreciate it a great deal. I'm going to ask the courtroom deputy to move us directly into the second case.
Mr. Bogart.
Mr. Bogart, we'd be happy to hear from you.
Thank you, Your Honor. May it please the court, we're grateful for the opportunity to discuss this matter today. My name is Nathan Bogart. I represent the petitioner, Mr. Carlos Escobar Gomez. It's an honor to be here, and I hope we can address the issues of importance to the panel. In the removal case of Mr. Escobar, the immigration judge, whose decision was basically just upheld by the Board of Immigration Appeals, denied his application for asylum and withholding of removal. The sole issue decided by the immigration judge and the board was whether Mr. Escobar's particular social groups were defined with particularity. It was a very narrow holding. At no point did the board or the IJ before consider whether the proposed particular social groups were socially distinct or composed of immutable characteristics. So any proposed particular social group must meet each of those three elements: that they're immutable, particular, and socially distinct within the society in question.
Well, the only question before us is particularity. Is that right?
That's absolutely correct. Yes, Your Honor.
So we don't get to the question of the immutable characteristic. We don't talk about distinct within the society in question because the board didn't address those. And so the only thing we have to determine is whether it was correct on the issue of particularity.
That's correct. Yes, we agree wholeheartedly. And so really when we get to—
Do we even know that this individual was a member of the proposed group?
We don't actually, Your Honor. That was never decided by the board or the immigration court below.
Well, I mean, it is an odd thing that I think it's the first case I've seen where it's unclear whether the individual is even a member of the group that's proposed, and I would think that you would have you bear the overall burden, and I would think you would have the burden of indicating that, or at least saying I'm a member of this particular group. And I mean, it looks like me, I have my real doubts. I don't know what murders you witnessed or when or what have you. It's just this statement. It looks like we're sort of ruling on sand here if you're not even a member of the group.
Right. No,
there's a problem.
I do see the problem, and the problem really goes back, I think, to the trial, and really how the immigration court, analyzed this issue. Is they really just honed in on that issue of particularity. They never got to the issue of whether or not he was a member of the particular social group.
Well,
obviously,
that's fine, but I would think you bear the overall burden, and I'm just I don't want to belabor the point, but I feel like I'm being put in an odd posture when it seems to me an easy enough thing for you to establish the group you want us to rule on by saying that here's the murder. I would.
Yes, I can understand that, Your Honor. I think that's a good observation. I think that, certainly from Mr. Escobar's perspective and what he argued below was that he was a member of that particular social group, particularly the particular social group of witnesses of a murder in El Salvador. And he did present testimony and evidence indicating that he had witnessed a specific murder and that he had been threatened because he had witnessed that murder. So, our position—
Didn't we confront the same situation in Amaya? I mean, that was a case in pretty much similar where we're going, and we even pointed out that case that that, the question of whether or not he was a member went to the issue of whether he was actually in that social group, not to the particularity of it. So there's been a situation we've dealt with, almost the same kind of situation where you don't know if he's a member. And I agree with Judge Wilkinson, is odd, but we've done it, and we recognize that in Amaya.
Yes, Your Honor. I would agree that Amaya is similar in that circumstance, that it hadn't really been addressed whether he was a member, and the main issue in that particular decision was the particularity analysis.
But that's why I wanted to focus it, because it is a narrow issue, and it seems like to me, I don't know why the board wouldn't go out and do the rest of it and bring it to us, but they decided on that narrow issue on it, and we made it clear that the question of whether you're in the group is different from the question of particularity.
Yes, they're two very different questions. Particularity is all about
the question of whether you're in the group. I have a problem with it, but I think it's only the beginning of my problems. And the particularity problem is, particular is the sort of antonym of general, and this just seemed to me a group that sprawls all over the place and includes people in circumstances that are wildly variable. One of the basic questions I have is that it includes both people who reported a murder and those who didn't. And if you look at the assault statutes as one which are primarily concerned with persecution, people are far less likely to be persecuted if they didn't report the murder in any way. And in fact, the gangs or whatever, people may never know who witnessed the murder. It may be completely an anonymous situation. Nobody else in the world or in El Salvador may even know if this individual actually witnessed a murder. And so it seems to me to lump people who never reported witnessing a murder with those who did. You're throwing apples and oranges together, and that's only it's only the beginning, because it includes citizens of El Salvador and those who are not. And you could be a witness to something on television and be a member of the group. And I don't know where we have ever taken a group that's this vague and open-ended and sprawling and satisfies a particularity requirement, because if the word particular means anything, it means something less than the open-ended kind of quality of this proposed group.
Yeah, thank you for clarifying that, Your Honor. And I think that, really when you get to the analysis of particular social groups in general, the board has established this three-pronged analysis. And what I think the Amaya court in particular tried
I'm having some hard time following you on that. What do you mean? If Judge Wilkinson clarified this, then your case is pretty much going down the tube. If he's asking for a response to the way he has put this, not thank you for clarifying it, because if you do that, then we can just stop right now. I think you mentioned Amara is similar, at least from my perspective, it looks like it controls. And that's where the answer to those questions would lie. Particularity, but persecution deals with nexus. And size is, at least we said in Amara, is not really material insofar as the question of particularity. So Amaya really controls the outcome of this case. But I think you need to be more specific in addressing Judge Wilkinson's concerns Because those are concerns that, on the surface, when you look at the words, I agree. When you look at particularity, it just doesn't make any sense from a common sense. But from an immigration perspective and the way the case law has been interpreted, it takes on almost a term of art from my perspective. So I think you need to go there and address it more specifically, what Judge Wilkerson is putting to you, because it's a good question.
Sure. So particularity is really more about self-limiting features. And what we're concerned about is whether or not the lines around the group are sufficiently clear to know who is a member and who is not. The size of the particular social group isn't necessarily going to be what determines particularity. I think,
but if they're wildly differing circumstances, and so many of those circumstances don't link up. You can call this a nexus question, or you can call it anything, but you can't ultimately get away from the ultimate requirement that the asylum statute was passed to prevent persecution and to provide a safe harbor for those who have been persecuted. And I can't recall where we have taken a group, a particular social group, and said it satisfies the particularity requirement. In fact, our own decision in Zelaya v. Holder, the court rejected as a particular social group, a group consisting of young Honduran males who refused to join the Mara Salvatrucha 13 gang, have notified the authorities of MS-13's harassment tactics and have an identifiable tormentor with MS-13. And even given the fact that that is 10 times as more specific and particular than the proposed social group here, it seems to me, we'd be just running roughshod over our precedent if we held something as general as this to be a particular group. All you'd have to do is witness shoplifting. Instead of murder, you could say somebody witnessed shoplifting, or somebody witnessed fraud, or somebody witnessed any kind of crime. And that would be a particular social group under the proposal that you've advanced. And it just we're making mincemeat of our precedent. We're making mincemeat of the statute if we go that far. That's really going a lot far. I mean, for example, the people in the group would include the murderer himself, or the murderers or accomplices to the murder. They would be witnesses to the murder. It could be somebody who's actually seen a murder in El Salvador from a completely different country and just watched it on TV, and nobody even ever knew that he had witnessed a murder. I mean, it just could include almost anyone. And the kind of things we found particular social group have been like members of a particular family or something like that, but they've had some outer boundary in order to qualify as a particular social group. There has to have been some outer boundary. And I don't see the outer boundary here.
Sure. So, when it comes to these outer boundaries, I think that the Zelaya case is a great example of a particular social group that isn't particular. And that's primarily because
you have a particular social group that isn't particular. Does that run afoul of the statute by concession?
No, I think that the Zelaya, the proposed group in Zelaya is a good example of a case that isn't particular. It's an extremely long group with several modifiers that are extremely vague, using terms such as young, using terms such as harassment tactics, identify.
What you ought to do is read the concurrent opinion in Zalal, which was concurred in by a separate judge, another judge, which made it a majority opinion. And that concurrent opinion said specifically persecution witnesses against gangs are sufficiently particular. So, you know, it wouldn't necessarily be a PSG, but it might satisfy particularity. And that's the only question before us. And that is a matter of jurisdiction that we're dealing with. I'm concerned as to how much you've really paid attention to Amaya on this case here, because that case looks to me to be on all fours in terms of where we go with this question here from a legal perspective. And then as you analyze this question as to what the board did, again, you know, there are other things the board can look at, but the board only focused on particularity. It doesn't end the matter. There may be some the other two may come into place. The socially distinct aspect of it, the whole business of nexus and all that, that's not before us. And that's you know, when the board makes a narrowed interpretation, a narrow statement of this on particularity, we're dealing with a jurisdictional situation here. And so there's a lot more to be done. And I think many of the concerns that Judge Wilkerson raised are quite valid. They're just not before us from my perspective. At least when you look at Amaya, when you look at the concurrent opinion, which is in fact the majority opinion, and because it's joined by that opinion was joined by one of the judges there. So it too is the majority opinion there. And that's what you really need to pay attention to.
Thank you.
Also, Mr. Bogart, the reason the board rejected your petition on the basis of particularity is because the particularity ground was so obvious and straightforward. And a lot of times, you know, there's a lot of dissatisfaction with the board, and I realize that. But actually, sometimes the board can get something right. And they took as an agency all the easiest and least disputable ground. And as I say, when you have a group that includes people whose perpetrators have been dead for decades and people who never reported murders, they're in no danger of persecution. You can, oh, that's all a matter of nexus. That's all a matter of nexus. No, particularity is a requirement, and you have to read the particularity requirement in line with the other prohibited bases, which are race and religion and other kinds of things. And they all, every prohibited basis in the asylum statute has at least some arguably definable outer boundary. And this is too diffuse.
Thank you.
You know, at any rate, Judge Wynn, do you have some further questions at this point?
No, I don't have any questions, Judge, but I do want to make it clear, at least from the perspective of this case, and maybe when we hear the other side, that Amaya is the case that really controls here. It's a case that came down after the briefing in this case. So it is instructive on what we're dealing with. It really goes to this whole question of whether the group is too diffused to be particular. And Amaya makes it clear that that even with this difficult question of ascertaining exactly whether or not he's a member, doesn't go to the particularity. And particularity goes to jurisdiction. And that's, I think, what the narrowness, but I do want to appreciate where Judge Wilkerson is going. Just from the perspective I'm reading Amaya is, those are not issues before us. And you're right, the board does get things right quite often. But in Amaya specifically, the panel made clear, we are, you know, we're going to assume there's Chevron deference here on this in that particular case on it. So it gave the board the due regard for it, but nonetheless reached that result on it. So I think we are just bound in this world by Amaya, and I'll be interested to hear how the other side articulates it.
Judge Floyd, would you like to Do you have any?
I have no questions.
All right. Let me, let's hear from your opponent here. Mr. Fiorino?
Good morning. May it please the court, Paul Fiorino. Can you hear me okay?
Yes.
Okay, if you
Yes.
can at any time, please let me know. I've been told that my microphone is a little bit weak, and I apologize for appearing audio only today. I was having some glitches with my video. To start off, to address Judge Wynn's question, we respectfully think that Amaya does not control this case and that it's distinguishable. Referring to the concurring opinion, the concurring opinion levers its concurrence on the reasoning in the Ninth Circuit.
You're talking
case.
about the concurrent opinion in the Zayella case?
No,
or in Amaya?
In Amaya. I'm referring to that, and it refers to Crespin-Valadares, which is a Ninth Circuit case. And in the Crespin-Valadares, the particular social group was defined as the family members of those who actively oppose gangs in El Salvador by agreeing to be prosecutorial witnesses. And
I don't know of a concurrent opinion in Amaya. I'm trying to understand that. As I understand, I remember that case. Judge Quattlebaum wrote it. Judge Thacker concurred, and Judge Richardson dissented. But I don't remember there being a concurrent opinion in Amaya. I think you're talking about the Zayella case. That was a case. A good colleague, Judge Floyd, wrote that concurrent opinion, but that concurrent opinion was joined by the other judge, another judge, which in effect made it a majority opinion for Zayella. And
Yes,
that's why I pointed out, in terms of the particularity, when you look at the language of that concurrent opinion, it's not a concurrent opinion, it's a majority opinion because it is joined by one of the three judge panels. So it's a 2-1 decision on that.
Yeah, I understand, Your Honor. If I can get back to why Amaya does not control this case.
Yes.
In Amaya, the particular social group was former Salvadoran MS-13 members. And in that decision...
Sound just as innocuous and unidentifiable as saying witnesses of a murder in El Salvador. That's why I say it seems like the same situation.
No, it's
not. In
not.
fact, it seems even more so former members of it. I mean, how do you determine that?
Well, what the panel in Amaya said is that the means of becoming a former member is irrelevant. Either you're a member or you're a former member, and that is clear. But getting back to some of the observations that Judge Wilkerson made.
But the means of becoming a witness to a murder in El Salvador is fairly straightforward, too.
Try to imagine, Your Honor, a football stadium or a soccer stadium with thousands of people, and on the football pitch, one of the coaches shoots and kills the referee for making a bad call. You've now created an entire particular social group, all the way from the players immediately close to the actual murder to people way up high in the
Good point. But Amaya says size doesn't matter. It is immaterial.
But
the counsel on the other side said is not relevant, or it's something you shouldn't consider. But Amaya makes it clear it's immaterial.
Well, I'm not saying it's the size. I'm saying it's the vagueness, as Judge Wilkinson pointed out. What is a witness? Is a witness a testifying witness? Is a witness a prosecutorial witness? Is a witness a defense witness? Is the witness to a murder in El Salvador a Salvadoran, or is it a person visiting El Salvador? Is it a person who witnessed a murder on television, or is it even a witness who heard about the murder who could be called to testify in court?
Now imagine taking the same thing in Amaya of a former gang member and doing the same thing you just did, and trying to determine what it is. Go through that same line of questioning. Is he one of this? Is there someone who does that? That's not what they did. I mean, I'm sensitive to where you're going with it, but I'm telling you, Amaya has pretty much locked this case in.
I disagree, Your Honor, and in this case, the board relied on Zelaya in its decision making. It didn't rely on matter of WGR as the board did in Amaya. And in Zelaya,
the problem with Zelaya is that concurrent opinion is a majority opinion, and it
Well,
too
I'm not
tracks
relying on
what's
the
here.
concurring opinion, Your Honor. I'm relying on the majority opinion.
Both of them are majority opinions. That's what I'm trying to say. The concurring is a majority opinion. It's joined by another judge, just like the first one is. The majority opinion has done it. So it's called a concurring opinion, but it's really a majority opinion.
Well, one of the differences that the panel observed about in Zelaya was that in Crespin-Valadares, there was an additional limiting factor of family membership, which added certain particularity that was logical and relevant to the particular social group being defined. Here, in Zelaya, they attempted to make the social group more particular by talking about whether the victim is the victim is victimized by one particular gang member or not. And the panel said that the concept that a person who is victimized by one gang member more than any other gang member somehow serves to particularize all such persons into a targeted social group is nonsensical. So what the panel did in Zelaya, the case which the board is relying on here, is it analyzed the logical relevance of what the distinction was. And even in that case, it found that the attempt at further distinguishing the case had no logical relevance, and it didn't serve to make the particular social group any more particular for the purposes of asylum, of a social group.
In this situation, if this is a particular social group, I have difficulty envisioning anything that wouldn't be a particular social group. I think we've read the word right out of the statute. Everything would be particular. I just don't think the Supreme Court's going to put up with that or anything close to it.
I agree, Your Honor. I agree with that, and that's why we think the board's decision in this case is correct and should be affirmed, and the court should deny the petition for review.
And it may ultimately be correct, and the Supreme Court may do that, but we are bound by the decisions of this court. And I'm telling you this, when you look at the Samaya case, it is right there at bottom. It tells you exactly what.
Well,
You're also, Your Honor, this court is also bound by Zelaya, the case which the board relied on in this case. Zelaya is no less persuasive and authoritative than Amaya is.
And I don't read it as being inconsistent because, as I said, when you add a concurrent opinion, what you've essentially done is expanded majority opinion on it. Everything that's written there is the majority opinion because they're concurred into by at least two judges of the three-judge panel.
Well, I'm not
so,
aware
to just look at the majority where you had the three judges agree to it and ignore what the concurrent opinion said, which expanded on what the majority said, that's the whole opinion. But I think we can go back and forth, and I could just say what's said here too, that you got a stadium full of people and that's a lot of folks. But I'm telling you that the law, in terms of this particular this specific issue that's before us, is pretty clear in Amaya, and we may read it differently, and may ultimately be that the Supreme Court might decide it's going to be differently, but I think we're bound by the law of this circuit and interpret it. And if there's a conflict, then maybe we need to get an en banc determination to settle this conflict.
Maybe it's always with some trepidation that I disagree with my good friend and colleague, but I don't see Amaya as being at all controlling here because Amaya involved a volitional act at one time to join a particular group with violent and retributory characteristics. And this doesn't involve any volitional act at all. It can be somebody who just happened upon a murder when driving along the street, because violence is regrettably endemic in El Salvador. And there was no act to join any member of a group. There was no affiliation with a group or blood tie with a group the way there is with family members, which are particular social groups. But to me, a volitional decision to join a particular group is different from somebody driving down the street who happens to see nobody even knows saw a murder, or in fact, it's just odd, almost to the point of silliness, to say that the particular group includes the murderer himself or herself. That cannot be. It has no relationship to any of the other prohibited bases. Is the asylum statute really meant to protect, as far as particularity is concerned, someone who is committing a homicide? Do we want, is that, I mean, you could make a particularity, you could make a particular group out of this by narrowing it to people who had reported the murder, and there would be some kind of public record of that, which would make them, I think, more vulnerable to retribution. Or you could narrow this group. Reporting is one way. You could narrow this group in a number of ways and make it particular. But this is presented to the board in its broadest and most diffuse form. This is, I mean, to my way, it's just unprecedented. And
Your Honor,
I think that I've said about what I need to say about it.
So it's clear for the council when you address that, just so you know my position and the way I read it, I do not think volitional act is required at all here. And I would like to hear, do you think it's required? And Amaya emphasized particularity as a line drawing. That's the only question here. So when you get into questions of, witnesses, I mean, even when you look at whether it's a former gang member, wouldn't you think that a witness of a murder would be more protected than the members of a gang? So that's the purpose of a particularity. But the question I want you to address, because Judge Wilkinson brings it up, what's the significance of volitional act insofar as determination of particularity?
Your Honor, volitional act isn't relevant for all particularity analyses. And
is it relevant here?
But it is relevant here because the particularity.
And what says that? Because you said it's not for all, but what case says that volitional act is relevant insofar as particularity? Or tell me where in Amaya that is recognized.
Well, like I said, I'm not relying on Amaya. I'm relying on Zelaya. And in Zelaya, the court said that the additional limiter, they drew an additional line of saying that we've now identified a specific gang member, and because we have identified a harm from a specific gang member, we've drawn a line, and the court said that's irrelevant. It's not just a matter of drawing lines. The particularity has to have some logical relevance to the claim. And in this case, the claim is that because he witnessed a murder, and because the murderer knows who he is, and the murderer threatened him, he will face harm. But the social group isn't just witnesses to a murder in El Salvador.
So is nexus relevant to particular determination of particularity? Is nexus?
No, Your Honor. It has to have a logical. There has to be a logical reason, a logical connection to the claim. If you look at Amaya, the particular social group was former MS-13 gang members. Okay, the MS-13 is relevant because they're the ones who are going to hurt him. The former is relevant because he left the gang and they don't like it when you leave the gang.
So I need you to help me
Those
just
are-
one thing. If you give me just one thing to help on it, tell me that language in Zelaya you are relying on. Tell me specifically, because I'm having some difficulty. You keep saying I'm not relying on Amaya, I'm relying on Zelaya, but I want to know what you're relying on. What is the language you say controls the outcome of this case from that case?
Okay, Your Honor, if you could give me a second here. I'm scrolling through the opinion.
I think I wrote that. Zelaya. Did I write it?
Well, first off, the Zelaya's proposed social group does not have the self-limiting feature of the family.
What page of the opinion? I want to read that, but if you just point me specifically to the part of it, I want
166, 166 and 167.
And the language you were relying on that says what?
It says Zelaya's proposed social group does not have the self-limiting feature of the family unit, which feature was critical to our holding in Crespin Valadares, that the proposed social group in that case had particular and well-defined boundaries. Okay. Then the court goes on to say, the fact that Zelaya's conduct in resisting recruitment, including complaining twice to the police, adds little to the particularity equation in the face of the common sense proposition that MS-13 would look unfavorably upon anyone who's complained about its harassment tactic to the police. So in that case, the petitioner attempted to further delimit his social group with an essentially irrelevant distinction. Yes, he drew a line. Yes, he made it more distinct, but the distinction he drew was irrelevant to his particular claim. And so what I'm arguing is that when you look at particularity and how a particular social group is defined, the limiting factors have to have some logical relevance to the claim that the non-citizen is advancing. Otherwise, they are irrelevant. And in this case, witnesses to a murder in El Salvador do not contain sufficient delimiting factors to define his social group to make it relevant to his claim.
What are you talking about? How do you define his claim?
Excuse me, Your Honor?
What do you mean by his claim? His asylum claim generally?
Yeah, his claim that the murderers are going to kill him because he saw them kill his friend. He was a direct witness and he was contacted specifically. But
Well,
look at how he's
say when my friend Judge Wynn said, "Well, does volitional choice have any role to play?" Where is that? Well, you won't find a dictionary of relevant terms of particularity, and they don't. There's no all-inclusive list of things that might or might not contribute to particularity. But what I think we get at by talking about volitional choice is that there is some obligation on the part of to supply limiting factors. When you supply limiting factors, you make it more and more particular. And the point here, when you don't have those limiting factors, and what is upsetting is that this group could have been so easily passable if just a meager effort had been to narrow the universe even marginally, and not just have this, this complete sprawl, and we were talking about precedent. I agree with you that Zelaya, and that quote you read, my friend Judge Wynn, was very relevant. In Zelaya, it was not. It was more particular by a multiple of 10, and the court said no, that isn't sufficient. And I don't want to repeat myself, but if this group is particular, then I have trouble envisioning any group that would not be.
Yes, Your Honor.
You know, that's that without, you know,
I see.
I always am happy to have him with word, and I promise that if Judge Wynn has something to ask, I will not speak further. Judge Wynn?
No, I have nothing further, Your Honor.
Your Honor, I'm out of time, but if I could just sum up, please. To pick up where Judge Wilkinson left off, yes, this particular social group is extremely vague and broad. It encompasses huge swaths of the Salvadoran society, as even petitioner concedes. Murder is endemic in El Salvador. Further, petitioner also concedes in his opening brief that witnesses to a crime itself is too broad, and the board's rejection of that was reasonable. I think he said that on page 11 of his brief. To the extent that the board's rejection of witnesses to a crime is reasonable, we would say that witnesses to a murder in El Salvador is likewise reasonable, because the social group still, for reasons I've discussed and reasons that Judge Wilkinson has illustrated, is way too broad, and to hold that as a matter of law that this social group satisfies particularity would essentially eliminate the entire requirement of particularity. So we would ask the court
Do you disagree with the holding in Amaya?
No, I do not disagree with the holding of Amaya, but as I've said...
So you believe it is a correct decision insofar as Amaya and the application of that case is of full force in terms of this circuit?
Well, it depends on what we're talking about in Amaya, because in Amaya, the court took the board to task for 3 reasons, and the board's reasoning in that case and its reliance on WGR, a factor not present in this case, was I think what was sound. What I'm saying is that Zelaya controls this case, and to hold that witnesses to a crime in El Salvador is a particular social group would essentially write that entire requirement out of the statute. So we would ask...
Well, I understand fully why you want to focus on Zelaya. I mean, before Zelaya and after it in Amaya, we only emphasized that our only question particularly was boundaries of the group. I mean, Zelaya does make a statement there, but I see why you want to focus on it. But we have this latest pronouncement here, and a pronouncement that conforms with where this court had gone previous to this Zelaya case. But even the language with which you indicate there, again, as I point out, Zelaya is not just what you read as the majority opinion. The majority opinion includes both that and the concurrent opinion. But I understand your point. Go ahead,
Mr. Fiorina, let me ask you this question. In the problem that's created here is that the immigration judge and the BIA did not consider the other 2 factors which could have helped alleviate the problem that we're arguing about on particularity here. So why should it not be sent back for them to consider the other 2 factors as well as the particularity, and then see where the chips fall?
Simply because, Your Honor, if he fails on particularity, he fails entirely. He could show social distinction. He could also show immutability. But if he doesn't have also particularity, his social group claim fails. And he's also waived CAT protection. So the only issue on the board is asylum and withholding. And in order to get either asylum or withholding, he has to show particularity. So if the court decides against him on the issue of particularity, there's no need to send it back.
But if you did send it back, and don't deciding those other 2 factors actually work as a filter or as a narrowing of the particular social group?
Well, they could help, but in this case, if the court, the only reason the court should send it back, and it would have to, by the way, would be if the court finds that the board erred as a matter of law and finds that this social group is particular. Then it would have to go back for the board to consider whether the social group is socially distinct and whether it's immutable. And so, well, but if the court, if as a matter of judicial economy and expedience, if the court decides that, you know, as a matter of law, this social group, witnesses to a murder in El Salvador, is not sufficiently particular, there's no need to send it back because the board would be bound by that holding and it would be pointless to consider the other two factors.
Judge Floyd, would you like to ask some additional questions or?
No, sir.
All right. Mr. Bogart, you've got some rebuttal time. We'd be happy to hear from you in rebuttal.
Thank you, Your Honor. So yeah, we would agree that this is a very narrow issue. When it comes to particularity, we're really just worried about whether the lines have been drawn clearly and in a way that's understandable. And from our position, that's the case here. You know, murder is a very specific crime that's understood. People generally know what murder is. People generally know what it means to be a witness. We know where the murder occurred because it occurred in El Salvador. Those lines are bright. Now, that group could include, in several different hypotheticals, several thousand people, but that doesn't mean the lines themselves are not drawn clearly.
What are you saying? That we know what it means to be a witness?
Generally speaking, yes.
Well, no, we don't. We don't know whether it's just somebody who has viewed something or, you know, I can be a witness to a dog walking down the street. But that term witness is used for a great many things. That's the problem is, you know, we complain about vagueness. I think that the burden lies not just ultimately with the petition, the burden lies with the individual who has proposed the social group to make it particular. And as I say, this would have been easy to make more particular in a way that related to the claim here, which is, look, I don't want to be I don't want to place myself in a position where people are going to come after me and retaliate against me. And it would have been easy to have resolved that problem, but it wasn't resolved. It was put, you know, it was put in a situation where we were asked to make an extraordinarily broad holding where all the ends of justice about people who are the targets of violence in El Salvador, the ends of justice could have been satisfied so easily instead of presenting to the board and the court something that is this broad and this diffuse and is going to have, I think, all kinds of unfortunate ramifications down the road. That's not difficult. It could have been narrowed and it could have been crystallized. You know,
Sure.
We deal with vagueness problems all the time, and this particular group is not only diffuse, it has a vagueness problem, and vagueness is disfavored in the law. So when it occurs to this extent. Anyway, I want to give you the final time so that you can sum up your argument.
That's okay, Your Honor. Thank you. So really, just to summarize, you know, our position is that the lines are clear, that we're using understandable terms, that adding additional modifiers would not necessarily help. It might help if you were to get into a social distinction analysis or an immutability analysis, but they don't necessarily help with whether or not we know someone could fit within the definition of this group or not, and that the board should have made the particularity finding and then gone on to the other factors of a particular social group. So we would ask that it be remanded for that purpose.
So
Let
what
me ask
factors
you,
should the board, what factors should the board have considered in ruling on this particularity that they did not?
Well, they never really got into the discussion of how murder might be different from the more generalized word crimes that were part of the first proposed group. And so Mr. Fiorino was absolutely correct. We did in our briefing concede that it was reasonable for the board to find the first particular social group was not particular because crimes is just huge. I mean, the definition of crime varies from country to country, jurisdiction to jurisdiction, but murder is much more specific. And the board never really addressed how that might impact things. In fact, it just said for these same reasons, we found the first particular social group to not be particular. The second proposed group is also not particular.
Well, I think it's going to be hard, to be honest, given all the different obstacles. It's going to be hard to bring this particular claim across the finish line. But at any rate, I feel like I've gone too long. Mr. Bogart, I gave the opposing counsel some extra time. Do you want a few minutes to just summarize what you want to say?
I don't believe so, Your Honor. I believe that the lines of disagreement are fairly clear here. But I do thank you for your time and for your questions.
Well, we thank you, Mr. Bogart and Mr. Fiorino. We're sorry not to be able to see you in video, but you sure gave a good argument nonetheless. And we regret that you are unable to come down and shake your hands, and thank you both for your fine argument. And I hope that they will come and greet every person in person and thank them for their service to the court. So, have a nice afternoon, and we will have a brief recess and then begin about a 5-minute recess and then begin our third case.
The Honorable Court will take a brief recess. The Honorable, the Judges of the United States Court of Appeal for the Fourth Circuit.
Mr. Cox, when you're ready, we'd be happy to hear from you.
Good morning, Your Honor, and members of the bench. May it please the court. My name is Daniel Cox, representing appellant Joanne Britt. It truly is an honor to come before you this morning. I thank you for that opportunity on behalf of my client. Your Honors, the Rehabilitation Act is designed to protect my client from retaliation, not to be eliminated from an action alleging the Rehabilitation Act retaliation. And here it provides the material causally related proof of the Department of Labor related limited duty workers' compensation, discrimination, and retaliation order through the Postal Service that the amended complaint plainly alleges. And without this causal nexus being permitted, the entire action is unable to be properly amended in the court below. As Good versus Virginia Legal Aid sets forth, as your honors are aware in 623, 624, this court does a case-by-case analysis under guidelines, which include that where an action and not merely an amendable issue in the complaint or amendable count is dismissed without prejudice, the order of dismissal is final and appealable. And in this case, we have an entire basis for the EEOC complaint being dismissed, and under count 3, half of that count being dismissed because it's causally and directly evidentiary related to the Rehabilitation Act claim. So my client's entire claim, your honors, rests on the Rehabilitation Act violations and retaliations, as well as the claim for discrimination and harassment and workplace.
Mr. Cox, in this case, was it appropriate for the district court to use the McDonnell-Douglas analysis? Because my understanding of that concept is that there's a burden of persuasion part to it, and there's been no discovery, and I was wondering whether that analysis was faulty.
Your Honor, thank you, and I would humbly suggest that it is, that the good court below heard in that under the Rehabilitation Act, my client is governed by not the race-based type of the McDonnell-Douglas analysis, but under the Rehabilitation Act, the Works v. Colvin indicates that she must show the protected activity, which she has shown. She must show the adverse action, employment action against her, which she has shown, and that a causal connection exists between the protected activity and the adverse action. Now, it's difficult for us to even proceed if we can't have discovery, because if I go to take a deposition strictly, your honors, on the issue of whether or not the employees who put the EEOC complaint into my client's postal box had understanding that that was an EEOC complaint, that the entire basis for the EEOC complaint, as well as the Rehabilitation Act complaints that necessitated this, is prevented in discovery. So it's placed my client in a catch-22 to be prevented from being able to discover the very nexus of the case, the gravamen of the case that underlines all of the complaints. And therefore, it is a dismissal of the action because we can't be expected, and my client does not have the money to go back after we do depositions on the timeline that we well pleaded of the EEOC complaint, to then go back later and do an entire new deposition string on all of the issues that underline.
Well, but do we have, we have to get to this point of a final judgment. And you suggested to the court, I think, that you would seek to amend the complaint if this were remanded to the district court as interlocutory. And I don't understand why you couldn't have tried a petition for leave to amend rather than taking an appeal.
Because, Your Honor, the issues were precluded. All of the counts were dismissed with prejudice, except for half or part of count 3. And so the entire action, the substance of the action, was dismissed.
No, because the retaliation claim was dismissed without prejudice. And you know, it would have been an easy, obviously, the causal nexus is crucial to a retaliation claim, and the district court was very distinct in saying some of these claims are dismissed with prejudice, but the retaliation claim is dismissed without prejudice. And at that point, the simplest thing to do would be to just petition for leave to amend and include 2 factors, which the district court actually bent over backwards and identified the factual gaps in the complaint. One being when your client filed the EEOC complaint was unclear, and it was also unclear when or even whether the employer supervised or even knew of it. And those pertain directly to causation and the retaliation claim. And I don't understand why you didn't just, the district court served it right up to you and said, I need to understand these. And I don't understand why you didn't move for leave to amend.
Thank you, Your Honor, and I'll explain in reverse order of what you pointed out. First of all, in our amended complaint, the court respectfully below erred, and because in Joint Appendix 8, Your Honors will see that on paragraph 20 and 21, both of those issues were plainly pleaded. It's specific to the date and specific to the fact that the individuals that the complaint was against placed the EEOC complaint in the mailbox of my client, as well as the fact that the date it was stamped was the same date that she was then terminated. But as to your question as to about amending, it would be fruitless, Your Honors, respectfully, in the underlying case, the action at bar to amend for the sole purpose of proving of restating what's already stated in this complaint, that on May 22nd, 2017, the EEOC complaint was date stamped and placed by those who she complained against in their hands, placed into my client's mailbox. Because, and here's the crux of the matter, the issues were precluded through the Rehabilitation Act by the court, such that we were prevented, therefore, from amending on the substance of this case. So, and the end result is to then deny my client the opportunity to make out any discovery beyond a very narrow window that has nothing to do with the action. The timeline of notice is directly tied into the fact that for a year, my client was persecuted because of her shoulder surgery. 15 years of service on the job resulted.
But you said it would be futile, but you said, I think you represented to us that you could have, that you would seek to amend the complaint if it were remanded to the district court as interlocutory. If there were amendments you could make.
Well, if the only cause of action left is this determination that that May 22nd, 2017, date stamped in the mail and hand delivered, if that's the only issue, and we needed to add another sentence to please the court below, that would not be a material change, and it's already there. The issue, Your Honor, has nothing to do with that. The issue is whether or not my client gets to proceed at all with the underlying discrimination claims, with the retaliation under the Rehabilitation Act. And so to go back and amend a date and time of notice has zero plausibility. It has a very narrow basis for which then she can have a case. And like I indicated,
well, you know, we have an institutional interest here. You have an interest in representing your client. We have an institutional interest in not having interlocutory judgments come up here and not having the a discrimination claim proper come up in one appeal, and then maybe a retaliation claim come up at some later time. It's just better for us to have the whole bundle up here at one point. And the dismissal without prejudice would seem to me to indicate that the district court was open for some sort of amendment. Otherwise, he would have dismissed with prejudice. But the district court said what he wanted. So these are the factual gaps. He indicated he was open to an amendment that you say was futile. But if the dismissal without prejudice doesn't indicate that it's futile, I just don't like these things coming up here piecemeal.
Thank you, Your Honor. And actually, this is the precise reason why this case is before Your Honor, not interlocutory as you suggest, but instead because the case law before this court that binds the court from the perspective of the Fourth Circuit is that to prevent multiple appeals, to prevent ongoing piecemeal litigation, it is important that the court take this on a case-by-case basis to see exactly what Your Honor indicated, and that is whether the entire action is at stake and whether that is sufficiently before Your Honors to then send it back so that we can properly do one case rather than bifurcate this as the honorable judge below has indicated through dismissing the entire action except for part of one tiny issue that has little to do with the substance. And in fact, if we begin depositions on that issue, we could be prevented from questioning about the substance of the EEOC complaint, because that's the Rehabilitation Act claim.
This whole question of jurisdiction and whether part or all of an action is dismissed, and this is definitely a non-final order insofar as it does it without prejudice. And we've allowed those in some instances in which maybe you would indicate you waive your right to in a future amendment, or as was said in Domino Sugar, that you could save your action by merely amending your complaint, which would go in the direction that Judge Wilkinson suggests. And the court itself seems to have pointed to some ways in which it could have been done. But the bottom line is, at least in this circuit, from what I see, it looks like we're kind of, I wouldn't say all over the place, but there's a lot of different directions this thing can go. And, I would think from the practitioner's perspective of whether you can appeal or not appeal, to have to analyze it on a case-by-case basis, that looks like to me it would be a nightmare to someone who's dealing with a case like this. Do you just go back and try to do it and risk later on a court saying you should have brought forth those cases that were dismissed with prejudice, or do you go forward on this one as interlocutory? Do you seek an amendment just on this part and then lose it from a statute of limitations or something on the other? It just looks like a nightmare to me. Is this the rule what is the rule across the board in other circuits? What's sort of the consensus way in which these things are handled? Well, you have what you have here, and that is, Judge Wilkinson rightly points out, and I'm with him in terms of there is a problem here from what I see, but whether it's been, your reason articulates a good way to handle it, it's something we'll have to consider. but it is definitely a non-final order, and that's jurisdictional. And the question then becomes, but you seem to be indicating it's futile to try to amend this because there's nothing else to amend. So that tells me you are waiving your amendment or not?
No,
Your
no,
right to amend.
Thank you, Your Honor. No, we won't waive anything, Your Honor, because what you pointed out is very accurate in that the court has put us, unfortunately, in a position where if we don't proceed, we risk issues regarding statutes of limitations, et cetera. And if we then go back, we could also end up being limited in discovery and have to.
Well, it keeps coming up again and again. It came up in Domino Sugar, then Chow, then Good, then back of Bean. The same kind of thing keeps popping up of whether we have jurisdiction or whether you should immediately appealable or not. I mean, it seems like to me there ought to be a rule change or something. You know, practicing law is difficult enough. I'm just thinking how scared I would be as a lawyer to make this call. And, you know, because you got to use your best effort and everything and use all your reasoning. But if you make the wrong one, you've just lost the case based upon a procedural rule there. And maybe I'm one that don't particularly care for procedural rules being vague. But I guess the question I'm asking is what rule would fit here that would give some greater clarity in how to proceed on a case like this? Or is there such a rule out there?
Well, Your Honor, the 11th and 2nd Circuits do make all dismissals appealable as a matter of right in any case. However, I don't believe Your Honors need to go there in this case because you do already have the authority under Good. It says very clearly that where an action, and not merely an amended complaint, is dismissed without prejudice, the order of dismissal is final and appealable. And the reason.
But then you got Bing that came back and basically looks like me. It says that Good's bright line rule was inconsistent with Domino Sugar and Chow. I mean, so you got a different panel that looked at it differently. And that's kind of where we all ought to place in between all this, or somewhere in the middle of this, is you, the practitioner, and your law license, and your client, trying to determine, is this appealable, not appealable? How do you handle it? And so that's why I ask what sort of clarity, and I'm not sure this panel can give it any more than the four panels already looked at this in different ways. And, you know, whether it's something that, you know, maybe the court en banc should settle or something, but is it unclear? I mean, you can argue it, but is there a lack of clarity in terms of the rule here, such that something really needs to be done so that from a practitioner's perspective, I'm asking more there, probably there's something a little bit more than what's to actually be done, but in terms of actually handling this case, is there some clarity we could add here that would make it simpler to make that determination?
And thank you, Your Honor, and that's the proffer that I'm making the court, that if, when you look at the dismissal, the entire dismissal, including all three counts, except for a portion, a very small portion of the third count, that means that's all dismissed with prejudice. And in that situation, this court has the authority to then.
No, but I don't think you're answering Judge Wynn's question, and it's exactly the same one that I have. And this is a traffic cop rule we're talking about, and our primary obligation is to provide some clarity. And there are a whole lot of cases in the circuit, at least, that where part of a case is dismissed without prejudice, then that's interlocutory. Then there's no final judgment where part of a case is dismissed without prejudice. And that's pretty easy to follow, and that's a pretty clear guideline. And there's always the danger in taking a traffic cop rule and trying to turn it into, well, sometimes it's this way and sometimes it's that way. You say it's just a tiny part of your case, but it wasn't. You brought a retaliation claim, and causation is not a tiny part. of a retaliation claim. It's a big part.
Mr. Cox, does it make any difference in this case that the judge ordered the entire case closed?
Yes, thank you, Your Honor. And that indicates, I think, an additional view of the court, and that is that this action was dismissed. Now, and furthermore, I would point out this was done on a motion to dismiss stage, not at the summary judgment stage. So we haven't had an opportunity to pursue any discovery in this matter on any count. And then when you look at even in the Chow case, as the court indicated, it clearly held that an action in entirety or dismissed in entirety can be considered. And so when you see this dismissed and treated as such as with prejudice, there is one particular question that as I pointed out, is inaccurate. The court erred on this point to say that our amended complaint did not indicate the date of when my client filed her EEOC complaint or whether...
If this goes back, how are you prejudiced if this goes back? You can shore up the gaps the district court noted in the complaint, and you would not have lost the right to appeal those claims that were dismissed with prejudice. I mean, it seems like, oh, well, this case we can sort of look the other way on the final judgment question. And, that might be okay for this case, and we might think that's a nice equitable rule. But the problem is long term. We're doing nothing to respect the institutional interests that we have in having cases not come up here in dribbles, but as one packaged whole. And that's, at any rate, you've got, if Judge Floyd or Judge Wynn has some additional questions, that's fine. Otherwise, I'm going to ask Ms. Cook to come and give her argument.
May I have a quick response, Your Honor, to that point?
Can you save the response for rebuttal?
Yes, Your Honor.
All right. Thank you. Ms. Cook, whenever you're ready. I'm sorry, I'm not hearing you. I think you need to put the audio back.
Apologies. May it please the court, Rebecca Cook on behalf of Appellee DeJoy. The district court correctly dismissed Britt's claims under Rule 12b-6 for failure to state a claim. Before we address the basis on which this court could affirm the lower court's decision, I do think we need to continue the discussion on whether this court has jurisdiction. As we've discussed this morning, because the district court dismissed Britt's retaliation claim without prejudice.
Can you hold for a moment? I'm having some problem with the audio here. I don't know if the other judges are not, but there's a lot of breakup that's happening right now, and I asked the tech to check on that.
Okay.
Is anybody else having that problem, or is it just me?
I think it's just you.
I think it's just you. I'm hearing things fine.
All right, let's come back now. Everybody's back. Thank you. Thank you. You may proceed.
Thank you, Your Honor. This court in Domino Sugar instructs that you must look at whether the grounds of the dismissal make clear that no amendment could cure the defects in the plaintiff's case. Domino Sugar also instructs to look at the clear import or bottom line effect of the court's order. The court also noted the difference between an order dismissing an action without prejudice and one dismissing a complaint without prejudice, stating that the latter order is generally not appealable.
So are you asking us to dismiss this for lack of jurisdiction?
No, I'm not. But let me walk. I think it's important we have to walk through the factors. Because you think we should take it then? In other words, you believe this matter is properly before us then? I think there's an argument to be made that it is, Your Honor, and some of that.
I need to know what your position is as the appellee on this case. Are you saying that we have jurisdiction or we don't have jurisdiction?
if Britt's counsel were to agree that she was standing on the amended complaint, it would be my position that this court does have jurisdiction.
Let's
And
assume
we
it's
have
not,
to-
because
we have
in
to
my answer to my
satisfy-
question, it seemed quite clear. He was saying, no, I'm not giving up any right to amend. That's what it sounds to me. So that's where you are. So do we have jurisdiction from your argument with that position?
With that position, given the other factors that the court has to look at that have been set forth in Domino Sugar, Chow, Bing v. Brevo Systems, as well as INRAE GNC Corp., I would say that this court, it would tip against this court having jurisdiction.
Well, I think we have to, regardless of what counsel says, we have to satisfy ourselves as to whether we have a jurisdiction here. And a lot of times this happens all the time, where counsel comes and wants us to decide this case and says that we do have jurisdiction, but we have a different perspective and a different interest in it. Yours is quite understandably, we want our case resolved, and then what happens down the road is something you got to live with. But I gather what you're saying is that your response to my colleague's question, that we don't have jurisdiction, looking at Domino Sugar.
Looking at applying the factors in Domino Sugar, as well as Bing, INRAE GNC Corp., and Chow v. Rivendell Woods, I think on the balance, those factors weigh against jurisdiction if Britt's counsel does not want to stand on her amended complaint. Because if you look at the Domino Sugar, says, well, is there any amendment that could be made that would cure the defects? As Your Honor noted this morning, the district court made clear what the defects in the retaliation claim were. The court did go ahead and order administrative closure, which could be seen as an indication of the courts being done with the case, but an administrative closure itself cannot turn it into a appealable order. Then you have to look at the factors in Chow and Bing and whether or not plaintiff is electing to stand on her complaint. In one way, because she pursued this appeal, that could be seen as her standing on her amended complaint. Even in the reply briefing, it would seem that they were standing on the amended complaint. However, it does seem, based on argument from counsel today, that Britt is not willing to stand on the amended complaint. So that would tilt against this court having jurisdiction.
So is that the way we have to handle these cases? I think you're right. When you look at Chow says stand on the complaint and the court dismissed the entire action, or was closed the case. And in answer to my question, it seems as though plaintiff's counsel says, no, we're not giving up any rights to amend or anything that was specific, and the reason for asking that was to get there. But I'm concerned, and as I'm sure the other judges are too, in terms of how do we go about this? Do we wait until we have arguments and then ask counsel, do you stand on your complaint? When does that come up? I think that's a dangerous way for a counsel to proceed on a case. To wait until you get here and say, okay, we'll stand on it or we won't stand on it. That seems like that ought to be made somewhere before we have to get to where we are. It's sort of dual. It makes us have to do what we're trying to avoid doing, is doing piecemeal type litigation. And it puts us in that situation. But when do you say that should be made, that determination of whether he's going to stand on his complaint?
Well, that is a factor in the analysis. And it appears that at least in Bing, INRAE GNC Corp., Chow v. Rivendell Woods, and I believe in Triple Canopy, it comes up at this stage in the appeal process. So it's one.
So you're saying when we're actually having an argument is when we first going to learn, or if you don't put it in your brief, I guess you don't have to, is when we're going to learn you're going to stand on your complaint.
It also can be.
I think this is kind of when I'm learning of it. Maybe it was said some other time, but I don't know anything to where we are. Seems like this is where you're learning of it. So is that what you're saying?
To some extent, yes. I mean, otherwise you can infer it from the fact that the plaintiff is appealing. But it is one factor that the court has
Yeah,
looked
but
at.
the plaintiff is not in control of the final judgment rule. That's the problem I have with the 11th Circuit case, is that whether the plaintiff wants to stand on the complaint or wants a chance to amend the complaint, since when do we turn over our jurisdictional standards to the plaintiff? The district judge is in charge of issuing something that's either a final judgment or is not a final judgment. And, I could not agree more with my colleague, Judge Wynn's concerns. I think we're in a mess. I think we're all over the place. And, I have been, I'm sure, probably not blameless, but we've got to have some clarity from the standpoint of future counsel to be able to decide these things rather than engaging in this kind of back and forth that we're involved in and trying to figure out all of the different factors and how they apply. It's a traffic cop rule, and it's so basic that traffic cop rules of procedure have to be clear. And so how do you head for clarity? You head for clarity by saying if one of the claims is dismissed without prejudice, it's not final. And that seems to me about the clearest way we can make it as a presumptive matter. That if something is dismissed and it's dismissed without prejudice, it just isn't final. And from the standpoint of a practitioner, wouldn't that be of help to you down the road?
Yes,
and in answering that point, I want to point to you that's exactly what Good said. Good rule, a bright line rule, and that's why we have a conundrum in this circuit. I agree with Judge Wilkerson totally. I don't like that 11th Circuit rule, but it's our law because that's what Chow says. Chow says a plaintiff elected to stand on a complaint and the judge close it. That's what we have. Then you have Domino Sugar that basically says it's a case by case. And then you got Bing that comes back and says, well, Good, you can't do this because you got Chow and Domino Sugar on this. I don't know how we avoid ultimately coming together and deciding a consistent rule. I'm not hung up on whether it should be one rule or another. It can go either way on it, but I think it should be the same rule. And I don't know how given where we are with the state of it, we could write an opinion, but it has no more force than the 4, 5, or 6 opinions already out there. Ultimately, this is one of those things we're just going to have to consider as an en banc court if the Supreme Court's not, and this is not the kind of thing I see the Supreme Court weighing in on anytime soon. Maybe they will because of the nature of it. But I don't know. I mean, to get clarity on it, I'm totally in line with Judge Wilkerson. I read this the same way. Who knows how to do it? And as I said, as a practitioner, I would be scared to death to be practicing and filing these things, particularly from a plaintiff's perspective, at the risk your action could be held dismissed or you didn't do something because of this myriad of cases out here that's in conflict as to what you can and cannot do. And, we judges having different opinions on it. But regardless of what it is, this is one of those areas, it's the uniformity of it that's the most important thing here by far. It's not trying to push one side or the other, but what is the rule? And we have a lot of rules. That's why you're struggling right now saying when is it that they can stand on the complaint? Now, it is ridiculous. We got to sit here and wait until you get here and have an argument for to hear the plaintiff's counsel say, I'm going to stand on my complaint. And, I mean, somewhere in advance, we should have known that, or at least assuming is the situation. But so I'm in agreement with Judge Wilkerson on this. I don't know where we go with it, except I think we've got to come together and make a rule.
Yes, and I agree with that. And I think you saw Bing trying to harmonize the prior cases and in that just walking through each of the factors, but then that still runs into how you weigh those factors. And in some of those cases, certain factors did appear to be dispositive. So to your Honor's points, the test is murky as it appears from the cases before us.
Ms. Cox, let me ask you this. Do you know whether or not the plaintiff is out of time to amend his complaint under the federal rules?
I don't know, but I believe the appeal would toll any limitations period. So I believe plaintiff would be able to go back and amend. I'm not positive though.
Let's assume that he is out of time. Then he would have to stand on his complaint, wouldn't he?
Yes.
Okay.
Yes.
And it assumes an interlocutory appeal will toll it.
That's right.
That's a risk.
And I apologize. I don't know the answer to that definitively. I apologize. There has been extensive discussion of the retaliation claim. So if I may, I'd like to turn to that to address that briefly. As everyone knows, the Retaliation Act bars retaliation against individuals because such individual has opposed any act or practice made unlawful by the Rehabilitation Act, or because such individual made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing under the Rehabilitation Act. To be clear, Britt's pursuit of workers' compensation or a modified duty assignment does not constitute protected activity under the Rehabilitation Act. When confronted with a similar question, this court in Reynolds v. American National Red Cross held that filing a workers' compensation request was not covered under the ADA, did not constitute protective activity under the ADA, and could not form the basis of the plaintiff's retaliation claim. Pursuit of a workers' compensation and limited duty assignment through the Department of Labor is a process separate and distinct from pursuing a request for accommodation through the agency, the latter being a protected activity under the Rehabilitation Act. Therefore, the only protected activity that Britt engaged in related to her EEO activity. However, the amended complaint fails to allege a causal connection between plaintiff's EEO activity and any challenged employment action. There's been much discussion today about the date of when she commenced EEO activity. That date is not clearly alleged in the amended complaint. However, in the ADR specialist inquiry report, the initial date of contact is stated in that document. That document is in the record and could be referred to by the court when considering a Rule 12b6 motion. However, there is still a problem with a causal connection because the complaint does not adequately allege when the defendant had knowledge of Britt's EEO activity. Mr. Cox points to the allegations in the complaint that Ms. Britt received back in her PO box a stamped copy of the EEO complaint on May 22, 2017. And that is the same date that she was informed that she was being terminated. There are no allegations in the complaint to indicate who put that envelope in her PO box on May 22, what was on that envelope, or what they knew. But more importantly, the notice of removal, which appears at JA 54, is dated May 19, 2017. So that is 3 days before this envelope was placed back in Ms. Britt's PO box. So it's dated May 19. It's signed by Ms. Wetzel on May 19, and it's also signed by Postmaster Adams.
Isn't this something for the district court to sort out in the first instance?
It would be, yes. I just wanted to make
so that would argue for dismissing as interlocutory, wouldn't it? Because what you've just been over, you may be right. I don't know. But, affirming on an alternate ground or whatever on the retaliation point, when the district court hadn't even had the chance to have the gaps he identified in a complaint were not addressed. It's unfair. It's unfair to the district courts to be affirming or reversing them on things they never had the chance to consider. It's unfair to litigants, as Judge Wynn has pointed out, to leave them with this incredible, murky case-by-case inquiry. It just seems to me that all these things you're talking about are not, not really things that, at least as it pertains to retaliation, are not things for us to be addressing here in the first instance. As to what date something was submitted, and, whether the supervisor knew when she filed a complaint, when or whether the employee or supervisor knew of it and everything. That's stuff you want the district court to address, and it's crucial to the retaliation claim. And you would want the district court to have a first crack at it.
Yes, Your Honor. And I just wanted to quickly pivot to address some of the merits in the event this court wanted to go into the merits of plaintiff's claims, or excuse me, of Britt's claims. And I just wanted to point out that even putting aside the facts surrounding the timing of her charge, there are no allegations and nothing in the record to support knowledge. The notice of removal was a part of the record down below and could be considered by this court today if it did decide to consider the merits of Britt's claim. And the point that I'm trying to make is that he's emphasizing, May 22, but the notice of removal was dated May 19. So before the envelope was placed back in her PO box. Also, again, if you will indulge me in more further merits discussion, there was a question, I believe, by Judge Floyd pertaining to McDonnell Douglas and direct evidence. I do believe that the court correctly applied the McDonnell Douglas paradigm in its analysis, and that is because the amended complaint does not sufficiently allege direct evidence. Direct evidence is evidence of conduct or statements that both reflect directly the alleged discriminatory attitude and that bear directly on the contested employment decision. It's evidence that the employer announced, admitted, or otherwise unmistakably indicated that the forbidden consideration was a determining factor. That's not what you have here on alleged amended complaint. You have one comment by Mr. Dar, one comment by coworkers. You have allegations that generally her supervisors denied her breaks, but there's no nexus between those allegations and the decision to place her on emergency leave or to terminate her. So for those reasons, it's clear that McDonnell Douglas does apply and there is not direct evidence alleged on the face of a complaint. If I see that I'm almost out of time, if the panel has no further questions.
All right, if my colleagues have no further questions, I will thank you for your argument very much. And then we will proceed with Mr. Cox's rebuttal.
Mr. Cox, before you start, are you out of time to amend under the federal rules?
Your Honor, that's a question that I wanted to address in the request that this court would clarify that by an order at the least of directing the lower court to permit the amendment.
Which leads me to my second question. Then are you or are you not going to stand on your amended complaint?
Well, thank you.
Because it has a jurisdiction. Wait, let me finish. Because it does have jurisdictional implications.
And because of the colloquy of Your Honors and my discussion during that time with my client, we are now going to, and my apologies, but we are now going to stand on the complaint for the sake of clarity for this court and for this case. And we ask that Your Honors reverse and remand and direct that the lower court permit the case to go forward for discovery. There are material substantive issues at play here that have not been inquired into. And as Your Honors pointed out, the judge below has.
So this is how we would do it in the future is, you file your action and then you come up to us and you make a decision whether you're going to stand on the complaint at that time. I mean, shouldn't that be made sometime before now? I mean, first you told me I'm not giving up any right to amend, and now in light of what we discussed with the state of the law, which I'm sure you already knew, you now flip and says, well, I'd like for it not be dismissed without jurisdiction, so we'll stand on the complaint and go in that direction. That doesn't give us any clarity at all in terms of what we do here now. We just added a layer, as Judge Wilkinson said. Now we're letting you determine jurisdiction for us at your leisure, pretty much when you finally get up here in front of us and now flip on us and say, okay, I'm gonna give you jurisdiction. Court, I'm not gonna give you all jurisdiction today. I sort of figure like our roles are being reversed here a little bit. I don't like that. I don't know how the other judges feel, but that doesn't feel too good to me. Is that the way it's going to work from now?
Well, Your Honor, that's certainly not the intent, and I think the issue was that.
Well, that's exactly what just happened. One moment if you said you wanted to amend, so we don't have jurisdiction. Now the next moment you says, all right, stand on the complaint. We got jurisdiction.
Well, Your Honor, I do have to follow my client's instructions, and I also wanted to mention that although once I hear Your Honor's position in the clarity issue that was brought up by Judge Wilkinson, I don't believe that is necessarily required of the court, but since that is the court's mind, that is my client's request. And so,
well, you earlier suggested that you would seek to amend the complaint if it was remanded. You suggested that to the court. And as Judge Wynn says, the whole upshot of what you're doing is you're blowing hot and cold on us, and you're flipping the roles so that you are in control and litigants are in control of this court's jurisdiction. And that just can't be. And this whole argument is underscoring for me not only the practical problems with this with the state of this rule, which is from a practitioner's standpoint must be a mess, but it also is theoretically very unsatisfying in that it lets the litigants play cat and mouse with the court over the court's own jurisdiction. And so whether you look at it from a theoretical standpoint or whether you look at it from a practical standpoint, it seems to me we need to go straight toward clarity, and the best way to achieve clarity is to say if part of the case is dismissed without prejudice, it's non-final, and we have a whole lot of unpublished dispositions that have dismissed appeals on that basis because part of the case was dismissed as non-final, and it was dismissed without prejudice. So we're trying to help you out, and it may be within our purview to direct the district court to allow an amended complaint, but I don't know whether, I have no idea what we'll do. But at any rate, do you have anything further because your time has expired?
Thank you, Your Honor. Nothing further.
All right. Thank you both. We appreciate it. And, I'm sorry we're unable to come down and shake your hands, but I know you understand. I hope the day will come when we can. Thank you very much, and we'll head into our last case. All right, Mr. Lang, we'd be pleased to hear from you, sir.
Thank you, Your Honor. May it please the court. Judge Wilkinson, Judge Floyd and Judge Wynn. Of course, my name is Louis Lang, and I represent the appellant in this matter. This afternoon before the court are two issues, both involving the denial of suppression motions by the district court. One suppression motion involved a statement my client made following a traffic stop on June 27, 2012. That traffic stop occurred about the same time, or approximately the same time, as a search of a home located on Stedham Road here in Columbia, South Carolina, from which my client had just departed in a blue Ford SUV. And that is the subject, or that search is the subject of the second motion, suppression motion that Judge Anderson denied. And that was an attack by the appellant on the affidavit that was submitted in support of that motion for suppression. The facts of the case regarding the traffic stop are as follows. On June 27, 2012, the search warrant, subject of the second motion to suppress, had been issued, and the Richland County Sheriff's Department had sent a search execution team to the vicinity of the Stedham Road house. My client, and in addition, part of that execution team was a investigator, Gwen, who set up to surveil the Stedham Road house. He did that for maybe 20 or 30 minutes, according to his testimony. And he observed my client going in and out of the Stedham Road house to the SUV maybe a couple times. After 20 or 30 minutes, my client got into the driver's side of the vehicle and drove away from the Stedham Road house. He drove for maybe one, maybe two blocks. It's unclear from Investigator Gwen's testimony exactly how far he got, probably about 2 blocks. And at which point, Officer Gwen, who was driving an unmarked vehicle, stopped my client, got him out of his car or his SUV, took him back to the unmarked police car, Mirandized him, and asked him where he was coming from, at which point my client said he was coming from the Stedham Road house and that he was...
What do we do with Judge Anderson's square actual finding? He says his hearing testimony reveals investigator Gwen had reasonable suspicion to make the stop due to a traffic infraction. And after that, there were Miranda warnings, and I assume that the subsequent questioning depended on whether there was reasonable suspicion of criminal activity. But what do we do with the factual finding that Judge Anderson made, that there was a traffic violation, that he had reasonable suspicion to make the stop? Just dealing with the initial stop.
Officer Gwen testified twice. He testified in 2015 at the trial of the case, and he testified again in 2019 after the remand. When he testified in 2015, which was, of course, much closer in time than 2012 when the actual stop occurred, he said that he stopped the vehicle, and when he was asked the question, and this is at Joint Appendix page 54, he was asked the question, did you charge him with anything, him being my client? And his response was, I did not. Now, when he testified again in 2019, for the first time, he said that he had stopped my client because of a failure to signal a turn. And I understand the question, Judge Wilkinson. I understand the problem. This court gives great deference to the factual findings of the district court because they're the people who actually see the witnesses testify and judge their credibility.
But isn't that the factual finding we're reviewing here?
It is. And I would suggest to the court that with all due respect to Judge Anderson, who's a fine district judge before whom I've practiced for many years, he just flat got it wrong. That statement in 2019 by Officer Gwen, 7 years after the stop, when Officer Gwen was no longer a police officer and could barely remember the events of June 27, 2012,
when you say he got it wrong, isn't it a question of credibility?
Well, it is a question. I'm sorry.
Isn't it a question of Officer Gwen's credibility?
It is a question of Officer Gwen's credibility, and we have a...
How do district judges get credibility findings wrong?
I'm sorry, Your Honor, I missed that last.
How do district judges get credibility findings wrong?
Well, of course, they have the opportunity, as this court doesn't, to actually observe the witnesses. But in this circumstance, which is relatively unique, we have an observation in 2012, actually in the trial of the case, where Officer Gwynn says nothing about a traffic stop based upon a traffic violation. And yet 5 years later, or 7 years later, he says, well, gee whiz, now I remember it was a failure to signal a turn. And there's no document ever produced by the government.
Did you bring the supposed inconsistency to the judge's attention?
I did, Your Honor, both at oral argument and in the brief I submitted, I believe, in support of my motion to suppress.
Okay, so
I'm sorry.
Excuse me, counsel. In other words, you're concerned about the inconsistency, fairly so, and you brought that to Judge Anderson's attention.
Yes,
and
I'm sorry.
You should have, and not with, so he was well aware of the alleged inconsistency, and he still made the factual finding that he did.
He did do that, Your Honor. But again, giving great deference to the factual findings of the district court is not the same thing as giving absolute deference. I think there have to be circumstances where this court can review that kind of factual finding based on credibility. And I know the court.
Let me just say another question. Was Officer Gwynn aware of the information that Officer Carwell had when he applied for the search warrant?
I'm sorry. Again, Judge, I'm having trouble hearing you. My apologies.
That's probably my fault. I was wondering whether Officer Gwynn, when he made the traffic stop and gave the Miranda warning, was he aware of either the actual affidavit that Officer Carwell had filed, or was he aware of the information, the background information that Officer Carwell had used in his affidavit?
You know, Judge, there's very little evidence of that in the record. The only testimony, I think, from Officer Gwynn or Investigator Gwynn at the 2019 suppression motion hearing was that, and I cite this in my brief, Officer Gwynn, I believe, said he didn't have a clue what cars or vehicles may have been mentioned in the search warrant itself.
Did Officer Gwynn have any involvement at all with the CI who went to the house with the funds and came away with the drugs?
No, sir. I believe Officer Gwynn, his only involvement was as a surveillance officer on the day, June 27th, the day of the execution of the warrant.
Did Officer Gwynn have any involvement with the CI?
No, sir. No, sir. He did not, as far as I know, had no involvement whatsoever with the CI. His only involvement began and ended on the 27th of June. And of course, the controlled purchase occurred on June 25, a couple days before.
Mr. Lang, was the seizure of Hall after the traffic stop ever contested below?
It was, Your Honor. It was not contested at the original trial of the case back in 2015. On the remand, it was contested by way of a motion to suppress where this very issue was argued before Judge Anderson, and Judge Anderson issued a written order, which is part of the joint appendix, denying the motion for suppression of that statement based upon what Judge Wilkinson and I were just talking about, and that is that alleged traffic violation. Judge Anderson found that there was probable cause to believe there was unlawful activity based upon that failure to signal a turn. So it was litigated the second time. The second time the case came before Judge Anderson, it was not litigated during the actual trial of the case. So given all those circumstances and those facts, Your Honors, I would suggest to the court that the seizure of my client at that traffic stop was unlawful, There's no basis, was no basis independent of the search warrant to do that. And accordingly, I would suggest to the court that the statements that he was made, were made, even though he's Mirandized, should be suppressed at this point in this case. Moving on, if I could, Your Honors, to the affidavit. Of course, the case on remand was for Judge Anderson to hold a Franks hearing. He did that last fall, in September, I believe, of last year.
Excuse me, I want to come back to the stop and question. I thought Officer Gwynn had observed Paul moving between the car and the home for 20 and 30 minutes.
He did. He observed, and he testified he observed my client and going to and from the home and the car, he said a couple times.
Yeah, hold on a minute. Why would he be observing Paul moving between the car and the home for 20 to 30 minutes if, as you say, he had no knowledge whatsoever of the information that Officer Carwell used in filing the affidavit for the warrant? I mean, Officer Gwynn didn't just show up in front of Paul's house by chance. Police just don't say, "Oh well, I think I'll go look at this." He must have had some reason for showing up outside of Paul's residence and observing the occupants' movements.
He did, Your Honor. He was part of the what I call the search warrant execution team, and his role, he was not going to enter the house. His role was to set up 20 to 30 minutes prior to the execution of the warrant and simply surveil the house. That was his testimony, both at trial and at the suppression motion hearing in 2019.
Well, he did know that the search warrant was going to be served?
He did. He was aware that the search warrant was going to be executed on the house. And his role was.
Well, if he knew that the search warrant was going to be executed, then was there not probable cause for the automobile search, irrespective of whether the Officer Gwynn had actually seen the warrant affidavit in its particulars? If he knew that there was an outstanding search warrant and that it was going to be served, and he was watching and surveilling the house, that would seem to me to contribute to the existence of probable cause in undertaking the automobile search.
Very briefly, Your Honor, I don't think Officer Gwynn he did not know, nor did Officer Carwell, the identity of my client. And that goes to the search warrant issue. There was nothing in the search warrant that would give anybody any idea of who lived in that house, who stayed in that house, who was associated with that house. There was nothing whatsoever in the warrant or in the affidavit that would give anybody a clue, police officer or otherwise, that my client, Harold Hall, was associated in any respect to that house. Now, in direct answer to your question, Judge Wilkinson, of course, I cite the cases of Summers versus Michigan and Bailey versus the United States, where the Supreme Court said in Summers that the police, that is, could detain individuals who are present at the scene of a search warrant execution. And in Bailey, the court kind of expanded that maybe a little bit and said police officers could detain those who were within the immediate vicinity of the execution of the search warrant. But my client was in neither of those places. He had driven at least 1, maybe 2 blocks away at the time Officer Gwynn stopped him and Mirandized him and asked him the questions, and he made an inculpatory statement, which is the purpose of this motion to suppress, to keep that inculpatory statement, which we suggest was the fruit of an illegal seizure of my client, from getting to the jury. I see my time is about up. Your Honors, I'd be happy to answer any further questions. I have 5 minutes of rebuttal time reserved, and would stand on my brief at this point in regard to the search warrant issue. Thank you, Your Honor.
Colleagues, have any questions for you? If there are no questions, we'd like to hear from Mr. Andrews.
Thank you, Judge Wilkinson, and may it please the court. I'll begin with the traffic stop issue, as that's the most recent matter of discussion that the court has heard. Your Honor, as Judge Wilkinson just indicated, the record is clear that when Officer Gwynn observed the occupants of the blue Expedition leaving the Stedham Road house, he followed the car for a couple of blocks. His testimony is that he then observed a failure to turn. He executed a traffic stop, and at that point, he was entitled, it was a valid stop, he was entitled to ask questions of the driver. In this case, Judge Anderson found that Officer Gwynn's testimony on that question was credible. And in fact, this issue was explored at length at the hearing, and he was cross-examined by appellant's attorney. And on redirect, he said he was simply never asked about this at the initial trial. So there's not an inconsistency here in the fact that there's any evidence that suggests it never happened. Perhaps there's a question raised as to why it wasn't raised in his initial testimony at trial. He explained that, and Judge Anderson accepted it. What you also have, though, here is an alternative means of validity for the stop, which is that you had the reasonable suspicion that the vehicle leaving this house.
One thing I wanted to ask you, Mr. Andrews, let's say he had reasonable suspicion to conduct a traffic stop. That doesn't automatically give you it gives you the ability to ask for a license and to ask for a registration and to do a data check. But does that give you the ability to just launch into questioning of an occupant of a car when someone's detained purely for a traffic stop?
So, Your Honor, I think it would depend on the nature of the reasonable suspicion. The court has found since Terry that the purpose of an investigative stop, the officer may ask questions. If there's a reasonable suspicion of criminal activity, the officer may ask questions in furtherance of that suspicion until the point is alleviated.
Right. Okay, now we get to the double. What was the reasonable suspicion of the criminal activity? Because your opposing counsel has said that Officer Gwynn had very little knowledge of Paul and his activity and the search warrant, and that it was going to be served. And he said really that he was just in a surveillance capacity and didn't have very little knowledge of the search warrant. I raised some questions about that, and I'm just wondering what your view is.
Well, Judge, I think that the record reflects that Officer Gwynn was familiar with the search warrant and the search warrant affidavit, and so he may not have known all the necessary background details, but he knew that a controlled purchase had been made at that house a couple of days before, and he knew that a magistrate had authorized a search warrant for that house looking for drugs and drug-related paraphernalia.
Had been indicated for that particular residence?
I'm sorry, Judge.
Had been approved for that particular residence?
The search warrant had been approved for that particular residence. That's correct.
Did Officer Gwynn know that?
He did know that. He had seen the warrant. He knew that it extended to vehicles that may have been related to the owners and occupants of the house. The appellant's counsel is correct. The vehicles
that makes it a little more than just a traffic stop.
I think, Judge, if you're asking the question of whether there was probable cause, I think that's certainly arguable. But I think there's no question that he had a specific, reasonable suspicion that there may be criminal activity. I want to go to the nature of the questions that he asked. The questions that were asked here are perfectly innocuous questions. And Judge, to your point, they're exactly the type of information that would already be reflected on a registration or a license. Once he conducts the stop, he asks Mr. Hall, who's the driver. He doesn't know who he is at that point. He asks him to step out of the vehicle. He gives him a frisk. He Mirandizes Mr. Hall because he has some suspicion that Mr. Hall may give a statement that's going to incriminate himself. And then he asks simply, where are you coming from? Who are you? Where do you live? And those are the types of questions that drivers are asked all the time during any traffic stop. Mr. Hall then gives a voluntary statement post Miranda, and it's not until after that, once Officer Gwynn receives a radio from his colleagues who are executing the search warrant, that the warrant has been executed, that he then takes Mr. Hall and the other adult occupant of the vehicle into custody and conducts the arrest. And so, Your Honor,
Mr. Andrews, was Mr. Hall arrested for the traffic violation?
No, he was not, Your Honor. Officer Gwynn speaks about that. He says, once we were able to establish that these people were associated with the house and with the drugs and the guns that were found there, I let those investigators take care of the charges. So he was never charged with the traffic infraction, but in our view, he didn't need to be. Once they had probable cause to arrest him on other charges, those were the charges that went forward. So once we have, the initial stop, he's entitled to ask some manner of investigatory questions. And I would suggest to the court that as far as an intrusion on privacy goes, these types of questions would be the least invasive that you could imagine. They really just go to who he is, where he's coming from, where he lives. That's at the point where he says, I live at the Stedham Avenue house and I live there alone. That's the incriminatory statement that's the subject of this entire proceeding. And I think you either have the reasonable suspicion for the investigatory stop. Judge Wilkinson issued or drafted the opinion in Taylor that we cite in our brief 30 years ago. Very similar facts in that case where the law enforcement officers were present at the scene of a house to conduct a search warrant. They saw people get in a vehicle and drive away. They conducted a stop, ordered everyone out, and at that point, this court found there was reasonable suspicion for an investigative stop before the arrest was made based on contraband that was found on their persons at the time. I would
address our decision in Taylor in light of the United States Supreme Court recent decision in Bailey.
So, Your Honor, I was just about to talk about Bailey. We would not urge upon this court that Bailey provides a foundation for this stop. We're not arguing that this would be the immediate vicinity. Obviously, in Bailey, the Supreme Court imposed a limitation on its prior ruling in Summers that really those types of detentions, which would be a detention solely for the purpose of holding a person while a search warrant is executed, they must be conducted in the immediate vicinity, and we don't believe this is in the immediate vicinity. On the other hand, I do believe that Bailey has quite a lot to say about the facts of this case. If you look towards the end of Justice Kennedy's majority opinion, Justice Kennedy says that our holding today in Bailey does not otherwise restrict in any way the ability of law enforcement officers to make otherwise valid stops in circumstances like these. Justice Kennedy specifically mentions that there may be circumstances such as those in Bailey and such as those here where people leaving the scene of a house that has been served with a valid search warrant may be detained briefly under a Terry stop for investigative purposes. Justice Kennedy also mentioned that in that particular case, had the search warrant team radioed the traffic stop team and told them that the warrant had been executed and recovered illegal materials, that you might have had a probable cause and valid, sufficient and independent basis in that case to make an arrest. I would urge upon the court that those
were the statements here made before handcuffing or after the handcuffing?
Your Honor, I believe that the record reflects that they were made before the handcuffing. I think it's helpful. The parties have been selective about what portions of the very vast record in this case have been included here. Obviously, we have the suppression testimony here, which is in the immediate joint appendix, but you also have Officer Gwynn's testimony at the initial trial as well. I think both of those read together provide a timeline here that makes clear that the traffic stop was made. He asked Mr. Hall to step out of the car. They walk back to Officer Gwynn's car. He's Mirandized and frisked. The questions are then asked, and it's not until later once the search warrant is executed and he receives word of that he puts the handcuffs on. One other thing I would mention.
Let me ask you one question. What do you think supplied probable cause here, and probable cause to do what?
Probable cause for the arrest, sir?
Yeah, I mean, you would have probable cause either for an automobile search or probable cause for an arrest. Which one are you talking about?
So I'm talking about probable cause for the arrest. That's when the handcuffs are put on. Now, at that point, Officer Gwynn is already in possession of the statement. Mr. Hall has said, I live there and I live there alone. And now he's heard from officers that there's 10 pounds of marijuana and 3 firearms in that house. So he puts those together. He's got probable cause to make the arrest. Now, as to probable search of the car, I don't think they searched the car. I'm not sure. I want to be careful about the representation. I don't know that the car is searched until after that arrest is made. At that point, there's a quantity, I think, of marijuana found in the vehicle. But certainly that search would be allowable under the automobile exception would be our argument. But as respect to statements,
what provided the probable cause for the automobile? For the automobile search?
That would be the arrest of the driver, and then we also have the issue that Your Honor raised earlier about the search warrant, which encompassed cars associated with the owners of the house. At that point, you have Mr. Hall's admission that he's the owner of the house. One other fact I just wanted to mention that the record bears out. At this point, Mr. Hall has been stopped. We know that his driver's license is in the pocket of a shirt back at the house wrapped in $1,000. This issue wasn't brought up at the hearing. I just point that out to the court that it appears Mr. Hall, who was driving the car at that time, did not have his license on him. And so you have a number of issues, I think, that grant Officer Gwynn the authority to ask him those investigatory questions and then to receive the answers he gets back, that he lives at the Stedham Avenue house and he lives there alone.
When the defendant was arrested, you were saying that the officers at that time knew what had been found at the house?
Your Honor, that's my understanding. He knows at that point that the search warrant has been executed. I believe that that's his testimony. And the trial record, I think, reflects
my question goes to what he knew as to what was found, not the execution of a warrant, or not that a warrant had been sought. At the time that he decided to arrest, which I think we probably can agree that handcuffing and arrest exceeded the permissible scope of a Terry stop, did he know what had been found at the house?
I can't.
Or did he only know that there was a warrant served and it was about to be executed?
I can't point, Your Honor, to a specific statement in the record that says that. I think the inference taken from his testimony is that he knew at that point that the contraband was found at the house. But if Your Honor,
inference from his testimony meaning what? I mean,
meaning that he testified, he received a radio.
He either says it or he doesn't say it. I mean, other than I just arrested him, and then it gets muddled about stuff was found, but you don't know it. He arrested him because of that.
That's
he's
right.
in a terrorist, and Judge Wilkinson's question goes to what then establishes the probable cause. And
the probable cause. Well, 2 points, and I want to be very clear with Your Honor. I cannot. What the statement that I understand to be in the record is that he made the arrest after the execution of the search warrant. I'm not sure that he expressly says that he had heard that the guns and the drugs were recovered, or that he was asked that.
Does the execution of a search warrant in and of itself gives rise to probable cause for an arrest?
It would not, and then we would not make that argument.
So what is it that gives probable cause to arrest?
Well, again, I believe that the record on the whole reflects that he was informed of the guns and the drugs that were found. I'm not sure that he expressly says that. I don't know if
well, I mean, I get where you're going. I think you probably answered it the only way you can. In other words, the record doesn't say that. You said on a whole, I don't know what that means. I mean, there's no testimony, there's no evidence there to say that. There's evidence, as you point correctly, to say, the execute, maybe the best is it's been executed, which means it could be in the process of going on or whatever. But the basis for probable cause is kind of vague right there.
So I'm not sure that I necessarily disagree with Your Honor on that. I do believe that the judge was allowed to draw an inference that he believes that the guns and drugs had been recovered at that time. It also could be possible that I've missed something in reviewing the record. I do want to point out, though, that by the time
but before you slide away from that, that sounds a little dangerous to me. I mean, we do want to allow reasonable inferences, but we write something like what you just said. It gives probable cause in a lot of situations where the officer may not have any clue as to what's there. You just kind of know, or I'm trying to get something a little bit more concrete there. That's beyond the Terry stop. The Bailey case makes that clear, and then it goes back to the Second Circuit, and it dovetails in this. But there's stronger evidence in that case that supports the probable cause.
Well, Judge, if I may,
but I want to be clear. That's really where I thought Judge Wilkinson's question was going in terms of, what gives you the probable cause here. And
I certainly understand. Excuse me, Judge. I certainly understand the interest of the court in trying to craft a good rule and reach a good rule here. But I would say that we don't need to get to the probable cause for the arrest, because at that point, this is about the suppression of a statement that has already been given. The statement has already been given voluntarily post Miranda during an investigative stop to the officers. And so
before the arrest happens, you're saying that statement is given incident to the Terry.
That's correct. That's correct. The stop is made. The officer is asking investigative questions. That answer is given, and it's not till after that the arrest is made. And so
we're talking about the suppression of the answers that were given after the Miranda warning.
That's correct.
What I was going to say is, I think Judge Anderson did. We do have specific factual findings here. I'm trying to look at this case as a whole in a little way, and we do have a naval district judge who held hearings both on the Franks matter and on the suppression matter, and there were several things that stood out in my mind about what the officer's conduct was here. I like the fact they gave Miranda warnings right off, and they absolutely should have gone around. Another fact that I like here was that the officers didn't just take the CI at his word. They conducted a conversation with him, and they supplied him with cash. And he actually went into the residence, and he came back. The officers frisked him again and found no cash, a quantity of drugs. And so they were doing their best to verify that. And another thing that, because I regard this as very narrow and fact specific, and nothing that would give rise to any big mistake or holding. But one of the things that
what was he arrested for, and how did he know what to arrest him for?
So, Judge Floyd, I think this gets back to the extended colloquy I just had with Judge Wynn. My understanding, and I think that the conclusion that Judge Anderson arrived at as well is that, and I think I should say too, I think Judge Wilkinson mentioned this in his dissenting opinion in the original case. But I think he receives word from the search team. Now, this is after they've gone into the house, after they've fully executed the warrant. At that time, they've recovered 10 pounds of marijuana, several guns, and some other things. I think that's what he's arresting him for. At that point, Officer Gwynn knows that Mr. Hall has told him, I live at that house and I live there alone. And so in Officer Gwynn's mind, he's the only person that could have been in possession of those guns and drugs.
I thought you made, in response to Judge Wynn's question and Judge Floyd both, that the statements were made, the statements that are at issue here had been made before the arrest.
That's right. That's correct, Judge. And I think the record, and I think you have to look back at the trial testimony, but you can also look at the suppression testimony. I think when you read those together, I think that timeline becomes clear that he asked him to step out of the car, he Mirandizes him, he asks him those investigatory questions, and the arrest doesn't come until later. And so I would encourage the court, I don't think the court needs to get to the question of the arrest itself and how sufficient the evidence is on that, because at that point you already have these voluntary statements.
And what statements are you talking about?
The only statements at issue here in this case, those that are sought to be suppressed by the appellant, is that Mr. Hall lived at that address and that he lived there by himself. As Your Honor may remember, that was a big issue at trial, as there was this house and there were allegations that multiple people lived there. The government introduced evidence at the time that it was primarily Harold Hall's address, but that was a contested issue, and so his admission that he lived there and that he lived there alone was a matter of some probative value for the case, which is why the appellant was trying to suppress it.
One of the questions I had, also, it seemed to me that this was a fairly coordinated police operation between Officer Carwell and Officer Gwynn. And I can't believe that Officer Gwynn was, particularly when he had been surveilling Hall's movements for that period of time, I can't believe that Officer Gwynn was ignorant of the search warrant or the goings on. He didn't just parachute into this whole thing. And so it seems to me that it's a fairly coordinated operation between Mr. Gwynn and Mr. Carwell. And beyond that, we can't, I just can't presume that, the district judge was non-existent. We're going into this carefully, as we should, but the district court he's a conscientious judge, as most of our good brethren are, but he listened to the testimony and he went through all this, and he's not one to just whitewash law enforcement actions. And I just think at the end of the day, we have to give him some credit on this kind of thing.
And Judge, we would agree with that. This is a credibility determination. There's no contrary any evidence in the record that suggests there wasn't a traffic stop in this case. And so we would certainly share that position. Very briefly, if I may, I know that I'm out of time.
All right, well, if there's no further questioning, I'd like to hear from Mr. Lang in rebuttal, unless you have something that absolutely needs saying.
We'll stand on our brief on the Frank's argument, Your Honor.
All right, thank you. And Mr. Lang, you have some rebuttal time, and we'd be pleased to hear from you.
Mr. Lang, could you unmute, please?
Would you unmute?
Yes, sir. My apologies. Again, the wonders of technology. I was going to inform the court that approximately 10 seconds after I lost my Zoom connection, Zoom emailed me with a 20% off offer on their latest product. So I don't think I'm going to take them up on that. In regard to the question of the traffic stop, I want to make sure that the court understands the government counsel is correct. The handcuffing occurred subsequent to the statements that we seek to suppress. So I don't want to mislead the court or get the court confused, but that is what Officer Gwynn testified to consistently, both at the 2015 trial and the 2010 suppression hearing. What he had to say, though, and I respectfully disagree with the government in terms of what he knew was going on in terms of the search warrant itself. He said this, when he asked, what did you do with the 2 male occupants at that point? And he's talking about at the execution of the search warrant.
You're talking about the search is subsequent to the handcuffing and the search itself and what he knew. The statements occurred before that.
Yes, sir.
Which would be under the pursuant to the Terry stop. So what he knew afterwards doesn't seem to impact that. So what is the basis for suppressing the statements before that happens?
Well, three bases. First off, of course, I would invite the court's attention, as I have before, to the Bailey case. And of course, I don't disagree with the government counsel's analysis of Judge Kennedy's opinion in that case. If there's an independent basis, of course, for the traffic stop, then Bailey doesn't apply. However, I would suggest to the court that there is no independent basis, and in particular, the Terry stop. Now, the record is not clear as to how much Officer Gwynn knew or didn't know about the warrant at the time of the traffic stop. But he did say this, and this is on page 138 of the Joint Appendix, quote, now the search warrant listed vehicles that could be searched at the residence. Do you recall? And the answer that Officer Gwynn gave was, I don't have a clue. I couldn't tell you if it did or not. I don't know if there was specific vehicles that were listed on the search warrant. I mean, he knew nothing about it. All he knew was that there was a search warrant that was going to be executed, and his role was very limited, just to surveil the house itself, the house that was subject to the search warrant. In addition to that, and this is a 2019 testimony.
I come back, Mr. Lang. I mean, the way you would portray it is that Officer Gwynn was just completely in the dark, and yet he is also surveilling this house, and he's now bound to have known that he was surveilling it for a reason. And what would the reason be other than the suspected drug activity? And that if there's suspected drug activity, it's very likely that an affidavit would have been filled out. And he's just not some stranger to this whole operation. But again, when you look at it as a whole, the fact that the district court held these hearings, the fact that a warrant was sworn out, the fact that that's what we want to do, the fact that they checked and double checked the CI, the fact that we have these findings here, and we have a warrant issue. There are instances of really raw bad police behavior, but I just can't see this as being one of those. And there are instances where the police just totally overstep their lines, but this just doesn't mean they invariably do so.
Well, let me just very briefly, my time is almost up, but invite the court's attention to page 47 of the Joint Appendix, where Officer Gwynn is discussing his role as a surveillance officer. I'll describe him as that. Basically, he says, we'll have an agent or two go to the location that we're going to be executing the search warrant. and we just do surveillance. See if there's any type of activity, movements, people coming, leaving the house, and we relay that to the entry team. That's what his role was. And what he saw was simply my client going to and from a car a couple times. And when he was asked later on in 2010, and I don't have the joint appendix site off the top of my head at the moment, but it was asked, did he see any suspicious activity? He said no. He just saw my client going to and from. And he had no idea who my client was, what connection my client had with the house, nothing at all like that. And so I would suggest to the court he had no basis for a Terry stop because he had no reasonable suspicion of criminal activity, putting aside, again, the asserted traffic violation. Now,
All right, thank you, Mr. Lang. I'm going to ask if there are further questions, because if they are, we'll just wait until they have a chance to ask those. If there are no further questions, I'm going to ask the courtroom deputy to adjourn court. Before you leave, I want to thank you both again for your arguments and just say we appreciate it very much. And thank you for your understanding about the need to proceed virtually. We wish it were otherwise.
Thank you,
each of you. I hope each of you has a very pleasant afternoon.
Thank you.
Thank you, Judge.
Privileged to argue before you. Thank you very much.
I'm going to ask if our good courtroom deputy if he would adjourn court and move us to our conference room.
This honorable court stands adjourned. God save the United States and this honorable court.